And until then, for Small Biz, Big Dreams, I'm Kevin Black.
The internationally acclaimed On Stage with Winfred Williams.
At a new time, Saturdays at 8 p.m. on CVM TV.
So much more than entertainment.
Let's delve deep into the issues. We'll take you beneath the surface.
Greetings and salutations. My name is Orville Higgins and it's another edition of Fan Central.
Talking to the people at the heart of the top sporting stories. Hear from your favorite sportsmen and women and the administrators who work tirelessly to make it all happen. It's a live sports talk.
I've written an entire article.
Yes.
Looking at all the major issues every Tuesday at 9 p.m. It's Fan Central.
Hello, good morning. Thank you so much for joining us here on CVM TV for this special broadcast, Silvera Learns His Fate. We are looking at the sentencing hearing for Jolyan Silvera, the former member of parliament who has pleaded guilty to manslaughter in the 2023 killing of his wife, Melissa Silvera. Now, with me in studio is attorney at law Alexander Shaw to help us, look at what will happen. Alexander is an astute attorney at law, is also a lecturer in law at the University of the West Indies, and a little later on will be joined on Zoom by senior attorney at law Bert Samuels and hopefully Leonard Green, who is the head of the Advocates Association. Let's go straight into it, Alexander. What are some of the factors likely to be considered in this sentencing? I can say right now to our viewers, we are checking and monitoring what's happening in court. Right now, we have inside court, several family members are there. The prosecution and defense have agreed to take the social inquiry report and the antecedent report as read. The Crown filed written submissions and 4 victim impact statements. Defense will have 3 witnesses. First defense witness just spoke, and the second defense witness is now testifying, speaking about their interactions with Jolyan Silvera, their knowledge of him. I mean, they are saying that they have never seen him angry. Before he gets angry, he walks away. That Silvera has 6 kids and is a good father. These are what will be known as mitigating factors. Attorney Shaw, what do these mean? Mitigating factors versus aggravating factors.
So the mitigating factors will assist the court in coming to an appropriate sentence, so that those mitigating factors will inure to his benefit. The aggravating factors are those that will somewhat exacerbate the sentence or cause the court to perhaps give a much higher sentence than is usual, or is part of the consideration for a higher sentence.
Yeah. Let me also ask you to go a little bit more into the aggravating factors. Aggravating factors in this instance, this is a 52-year-old man. His maturity may go against him because the judge may say, boy, really and truly, he should have known better. Explain for our viewers the different kinds of aggravating factors that may be considered in a matter like this.
So one, we're talking about an offense that a firearm was used. And certainly what the authorities have said is that planning or premeditation, the type of weapon that was used. So the use of a knife as opposed to the use of a gun. Also in terms of the force that was used, was it a case where they were having a struggle and he used excessive force? The case of domestic violence, which is evident in this case, as well as the history of domestic violence to either party, be it the defendant or the victim, and previous convictions. I doubt he has a previous conviction, but that would also be a consideration, as well as the indifference of the accused person. So how it is, whether he assisted the police post the killing. And I think we have seen, a lot of demonstrations over the last few days regarding that, because persons are saying, well, he never assisted the police, and the police had to come to this conclusion on its own volition. So those are factors that the court will take into consideration in coming to the appropriate sentence.
And just to bring our viewers up to date, initially it was said that Melissa died in her sleep, so it wasn't until a post-mortem was done that they found bullet fragments in Melissa. So that will work against him, is what you're saying, as an aggravating factor.
Because if you're saying that you were provoked, you lost self-control, there's nothing barring you from assisting the police. And if you're and you're talking about a spousal relationship, husband and wife, and so you would really want to seek urgent medical attention, be it you summon the police or those involved in medics to assist her. None of that was done. And so those factors will be considered as aggravating factors.
You mentioned the protests that have been taking place over the past few days, and our reporter Kevin Black, we should say to our viewers, is in court and will give us the very latest as soon as the sentencing begins. And of course, we'll also be going to the live stream from the Supreme Court in downtown Kingston when Chief Justice Brian Sykes begins his remarks in this matter. But to go now to a report by our reporter Kevin Black, who earlier this week went to Emancipation Park, where the family members and friends of Melissa Silvera staged a peaceful protest.
All in black at Emancipation Park in New Kingston on Tuesday to demand justice for Melissa Silvera, the woman whose death sparked public outcry, further intensified by the subsequent plea to the lesser charge of manslaughter by her husband, politician Jolyan Silvera. Protesters carried signs criticizing the plea and demanding accountability, saying provocation should not justify taking a life.
Well, as a concerned Jamaican citizen, I heard about the protests and I decided that it's time I came out and let my voice be heard, because it's an important issue that faces a lot of the women and the children in the society. The stigma is there against women and children, so I decided to come out and end the violence against women and children, and let's break that, that norm that has been plaguing Jamaica for many years.
Violence, domestic violence that continues to plague our society. It has been ongoing, and I just think, we have to send a clear message that enough is enough.
This is not right. Don't care what you said in your mouth, it's not the same as a gun.
They told the CVM News the gathering was not only about one case, but also raising a stronger national voice against the violence toward women. Family members, schoolmates, and friends say the death of Melissa has left them depressed. Protesters demanded justice for Silvera while calling for stronger action and accountability.
She was a very good person, very kind person, loved her husband, enjoyed our children to the ultimate. I was so shocked, traumatized.
For Melissa Silvera, which is my best friend, and it's because of as everybody knows, that her husband killed her, and so we're here protesting that provocation is no justification.
You know, her death rocked us because we haven't had a tragic death in our year group, you know, under these circumstances. And every time you hear the story and it evolves, we feel shock.
There is no way that we can go from chemistry class and the canteen and chatting and sitting on the ground in our immaculate uniforms and then moving to one of us is horrifically killed and their children. Where's the justice?
They told the CVM News the gathering was not only about one case but also raising a stronger national voice against violence toward women. Family members, schoolmates and friends say the death of Melissa has left them depressed. Protesters demanded justice for Silvera while calling for stronger action and accountability.
Melissa's death was not for nothing. We intend to give her a voice, the voice she no longer has. And we intend to say to every woman who is out there struggling quietly and silently, because let's be real, Jamaica has a very strong victim blaming and shaming tradition. We want to abolish those traditions.
For the legislation to be changed, for provocation to be wiped off of the books of Jamaica, where it's not accepted as an excuse or a reason for somebody killing another person.
Justice should be harsh and should be swift.
Sentencing for her husband, Jolyan Silvera, is set for this Friday. Chief Justice Brian Sykes says the proceedings will be live streamed. Kevin Black reporting for CVM News.
All right, so that was the protest that was held earlier this week, I believe on Wednesday at Emancipation Park. How will something like this, if at all, be considered? The kind of the public mood towards this case, the public reactions to this matter?
Usually the court would request a social inquiry report, and that report would take into consideration the impact, the victim impact. So how this offense impacted the victim. And this demonstration certainly forms part of that, because where there is public outrage, it simply means that this killing was one that horrendous, as one of the protesters puts it. So it will be considered, and you're talking about a matter that, you know, has garnered widespread public attention. But importantly, though, the case law will tell you that the ultimate consideration is the man in the dock. And so while the court will take into consideration all that's happening around it, it has to take into consideration what is before it, the evidence, as well as what is presented from the accused person. So there will be a balancing exercise, a very difficult one, I may say, but let's see what happens.
In terms of and I can just say again, we have been, we have people in the court and we are tracking this, just to update our viewers before we go over to the Supreme Court for their feed. What is happening at the moment is that defense counsel Peter Champagne is now making his plea in mitigation. Explain for our viewers what this means, Mr.
So
Shaw.
the plea in mitigation, earlier we talked about mitigating factors. The plea in mitigation is where counsel will seek to move the court on his client's behalf to say, well, listen, we have done something wrong, but these are the factors that you should consider in favor of us. And the Crown, more recently now, has a chance as well to make submissions. So there are mitigating factors, but and to benefit from that, because we're talking about a case where children are involved, and you know, he has pleaded.
Aggravating factor, perhaps.
It could be seen as a mitigating factor because
and this I'm trying to play devil's advocate here. It may be argued by the prosecution, the Crown, that, you know, he left his children to find to discover the body of their mother, because he wasn't the one who necessarily who discovered her body. The children found their mother's body, and also they will now have to live the rest of their life with the stain of this memory etched inside. How is that a consideration at all? I'm asking.
It will certainly be a consideration for the court, but then the court has to balance that with taking away both parents, because one is dead and the other will be in prison for how long? You know, you really don't want children to suffer, you know, the absence of both parents. And so whilst it is an aggravating factor, I am pretty sure his attorney will use that to couch an argument in favor of an early release from prison.
Yeah, just to say as well that Mr. Champagne is highlighting issues for the judge to consider, saying that Mr. Silvera has had no previous convictions. He's been in custody for over 2 years, 1 month and 11 days so far. So these are the elements of the plea mitigation currently being put forward by defense counsel Peter Champagne at court. The other matter now, though, you mentioned the children and being raised, but the amendment to the Firearm Act 2022, he used a firearm to commit a felony. There's a minimum sentence here of 20 years, a maximum of 25 on this. Correct me if I'm wrong.
Well, so the minimum is 15 years.
Using the firearm to commit a felony?
Well, no. Well, the presence of the firearm, because the firearm was used in a very illegal way.
Right.
But so the minimum is 20 years, as
right.
you rightly said.
Yes.
So that will also be a in fact, that will be an aggravating factor.
Yeah, and therefore, so that already there, our viewers can look, and that may be the heavier of the two matters here. So he's guilty on 2 counts, the firearm to commit a felony plus the manslaughter that he has pleaded guilty to. The firearm offense, there's a mandatory minimum here of 20 years for him. I raise that to say he won't necessarily be back to raise his children by the time he gets out, if he is alive, perhaps.
Well, certainly because of the mandatory minimum. Because when you look at the offense that he has pleaded guilty to, manslaughter, the range that the court will actually consider in a case like this, I would want to believe 14 to 18 years based on the authorities. Because we're talking about a case where he has pleaded guilty and the authorities, well, there is the sentencing guideline, and even though it doesn't fetter judicial discretion, the court will use that to guide it in deliberating what is appropriate in this context.
I do want to go a little bit more into sentencing guidelines and what role will precedent play in something like this. There was a similar matter in terms of a firearm was used, it was an intimate partner violence, the Andre Broomfield case, I believe it was.
Yes.
That's the gentleman and viewers may recall this incident happened at a supermarket in Manchester some years ago. I think that matter was concluded in 2024. He was given, he's serving 18.5 years for that particular matter. But some of the circumstances, though, Mr. Shaw, are similar. How will that factor into Chief Justice Sykes when making his decision?
Well, there is the sentencing guideline. There is also the Criminal Justice and Administration Act, as well as case law. So he has to consider all of that. He's not... precedents will guide him as to what is appropriate, but because of how unique sentencing is, because it's a case-by-case situation, so yes, he perhaps can take some guidance from that authority, but he has to take into consideration the specific facts before him. And so what the authorities have said is that sentencing guidelines should not necessarily fetter a judge in looking at the man who is before him.
Yeah, and what will I mean, so yes, there are the mitigating factors that the judge will consider. There are also the aggravating factors that we have discussed as well. Talk to us about and explain for our viewers what, for example, the antecedent report and the social inquiry report, what are these issues to be considered as well?
So the antecedent report is the report of his good standing or any previous convictions that he may have had or he has, and I don't believe he has any. So his antecedent.
Champagne has just said that there isn't any criminal conviction in the past.
Precisely. Right? So that will inure to his benefit. The social inquiry report, which we call the SER in short, is a comprehensive statement that takes into consideration everything about him, his age, how he acted, pre and post the offense, children, his association, his ties to community, all of that. So the SER and certainly those who the probation officers, they get a say in all of this because they can recommend, having interviewed all the various persons, the children, the friends, the family, they will get a say to recommend to the judge an appropriate sentence, having considered all the relevant factors that are unique to this particular case.
Yeah, there's the other issue now, and just to give our viewers another update in terms of what's happening in court, no witness has suggested that he has a violent streak. Of course, we won't be naming any other witnesses for safety reasons, and the court has indicated that we are not to name the witness. He also, a mitigating factor, he gave service to community as councillor and member of parliament. When we come back, we want to discuss some more of this matter, but we will be taking our first break here on this special coverage. Jolyan Silvera learns his fate. He'll be sentenced today in the November 2023 killing of his wife. He has pleaded guilty to manslaughter and using a firearm to commit an offense, though a felony. Those two charges he has pleaded guilty to. I'm Giovanni Dennis. With me is attorney at law Alexander Shaw, and when we come back, hopefully we'll be joined by Bert Samuels to help us to dissect this matter. Stay with us here on CVM TV. We'll be right back.
This is deposit insurance in a minute.
Under the JDIC, business accounts are insured separately from the owner's personal accounts up to 1.2 million.
Hold on there. So my little shop money and my little savings money insured separately?
As long as your savings and business accounts are in a bank or building society.
Well, that's not bad.
To learn more about how deposit insurance works, visit the JDIC website at www.jdic.org
or follow on Facebook, Instagram, and X at JDIC Jam.
JDIC, protecting deposits for you and me.
Here, where the Caribbean greets the morning, elegance isn't just seen, it's sensed. Set on Jamaica's north coast, the Montego Bay Convention Center rises with intention. A space designed to inspire, connect, and lead. Polished, purpose-built, poised for what's next. Step into a venue where scale meets serenity, where openness isn't just a design, it's a philosophy. This is more than a venue. This is where vision checks in.
Welcome back to Silvera Learns His Fate, the special coverage here on CVM TV of the sentencing of former Member of Parliament and businessman Jolyan Silvera, who has pleaded guilty to two charges, the charge of using a firearm to commit a felony and manslaughter in the 2023 killing of his wife. He says he was provoked. And just to give you a bit of an update in terms of what's happening in court right now, we should say to you, as soon as the stream is up and available from the judiciary, we will be taking you over to the Supreme Court when Chief Justice Brian Sykes begins his summation and his remarks in this matter. Attorney at Law Defense Counsel Peter Champagne Casey is now doing his plea in mitigation. He has highlighted so far that his client Jolyan has no previous convictions. He's been in custody 2 years, 1 month and 11 days. He gave service to the community as councillor and a member of parliament. He has admitted that the circumstances of the case are in fact disturbing, but said that Silvera did the honourable thing and pleaded guilty. And this has spared witnesses and the children especially. Pleading guilty for Silvera, it will allow him his lawyers can ask for a reduced sentence because he has spared the court the time of a trial. How does this part work? How does him pleading guilty inure to his benefit in sentencing?
Well, because you don't waste the court's time. That's the most important thing. And it is, well, it's somewhat a sort of remorse late in the day, though I must admit, but you are now taking, responsibility for your actions, and so the court usually discounts your sentence for that. And interestingly, what we have to take also into consideration is that provocation, his defense here, is also a mitigating factor. So he could have gone to trial and still come back to a manslaughter conviction. It's just that perhaps the sentence would have been more because that would have been aggravating for him to know that, oh, I actually did it, and then you waste the court's time, took us through a lengthy trial when you could have saved us some time.
Okay, the consideration though, going back again, yes, he has pleaded guilty, but the fact that he didn't come clean at the first attempt. So let's go back to that Andre Broomfield case. In his matter, he shot and killed his girlfriend in plain sight. It was captured. He went the next day to police and pleaded guilty, and he said, listen, I've done this thing. She'd gave me a bunch. She was kissing the guy in front of my face, and me feel away, me build house for us in our school. All these things he had spoken about. So he didn't mislead police at the first instance. And they took 10% of his sentence. No, in this matter, there was an attempt to mislead investigators to suggest that she had died of natural causes. Even though he has pleaded guilty before trial, is that not an aggravating factor?
It is an aggravating factor. It is because, and remorse is very important. Having done the act, you realize, whoa, this is my wife. Because what he's saying is that he lost self-control. But having regained self-control and realized what is at stake now, the ordinary man would seek to assist the police. He never did that. And so these factors will be taken into consideration as aggravating factors. You spoke about the discount. The Criminal Justice and Administration Act allows for up to 50% discount. It's very discretionary, which means that the judge will have to take into consideration what is before him in that.
Discount in instances where he has pleaded, where he has pleaded
guilty. So an early plea will afford you a much a higher discount. You can get up to 50%. But if you wait until the very last minute to plea, and he has been pleading not guilty for, from the start of the case, and the case was in plea and case management court for a long time, and he could have seized that opportunity. He did not. And so what is really at stake now is whether he will benefit from a high discount. You spoke about 10% in that particular case. Well, he will get a discount for the guilty plea, but we can't say how much. The court perhaps will give him 10, perhaps less.
Yeah. Will Chief Justice be guided by that very recent case because of the similarity in the circumstances in the Andre Broomfield matter? And just to kind of bring our viewers up to speed again, the Andre Broomfield matter, I'm referring to that one because it was a similar case, and so that would be precedent in this matter. He's now doing 18.5 years in that case, and the circumstances of this case, he domestic violence as well. He shot and killed his girlfriend. In this instance, it's the wife of Silvera who was shot and killed. A firearm was used to commit the offense. A firearm was also used in that matter. He got a discount of 10 years for his guilty plea, and the appeal court had agreed with the trial judge in that matter as well. Will Chief Justice Sykes necessarily give less of a discount to Silvera because of the attempt to mislead initially? Because in that matter with Broomfield, the first attempt, the very next day after the shooting, he went to police, surrendered his firearm and magazine with no ammunition, and he confessed to it. That didn't happen in this case.
And certainly that is aggravating, because a mitigating factor is if you assist the police. So if you don't assist the police, then it's going to be used against you. And you spoke about him trying to cover up this. So that post-offense activity, you know, is something that will not assist him at all. So it's very difficult. You spoke about whether the judge, whether Chief Justice will actually look at that popular case of Broomfield. But what I can say, though, is that he has a plethora of authorities before him.
What are some of the other authorities he can mention?
There is, the guiding principle is Misha Clement. One would say that is the starting point in sentencing.
So, Mr. Shaw, remember our viewers are not necessarily versed in all these matters. So you have to give us the background to that case. Tell us about that Misha Clement case.
Is a case that really sets out how a judge should approach sentencing. And you have to be very clear in that. Ensure that you establish a starting point. Let us know where you are coming from. Let us know the factors that you have taken into or will take into consideration. Let us know how it is that you treat with all the varying issues, because what you have put on the table, Gio, are a number of issues that he really should consider. How we will know if he has considered them is if in going through the sentencing, he tells the court, listen, I will take this into consideration. I will discount you for this. I will not discount you for that. So Misha Clement is that case. Well, in terms of the manslaughter specific authority, there are a number of authorities, and Broomfield is one authority, but there are a number of authorities, and I think importantly, he will also have to be guided by the sentencing guideline, because what you want, the purpose of the sentencing guideline is to ensure that there is consistency in sentencing, because you don't want a case of similar facts, one gets 25 years and the other gets 15 years. So
that's why I have
in the grand scheme of things, the sentencing guideline is there to sort of give some guidance so that the judge doesn't go outside of the appropriate realm.
Yeah, we are upon another break. When we come back, we'll be giving you some of the very latest in terms of what's happening in court. Just to remind our viewers that we are looking at the Jolyan Silvera matter. He learns his fate today, where he will be sentenced. Currently, his attorney at law, his senior defense counsel, Peter Champagne KC, doing the plea in mitigation, which is essentially saying, Judge, these are the good characteristics, the good traits of my client. This is why you should give him a discount in his sentencing. The social inquiry report, the antecedent report, all these are matters being considered by the court as we speak. Of course, we should say to you as well that the prosecution and defense have agreed to take the social inquiry report and the antecedent report as read. Yeah. The Crown filed written submissions and 4 victim impact statements, and the defense had 3 witnesses this morning as well. One of the witnesses has said that he knew or has known Silvera for over 2 decades, and that Silvera has 6 kids and is a good father. He has also said that he was surprised and shocked at the charges because that is not the man he knows. A second witness also spoke, and so that is what has happened so far. We will be going over this to the Supreme Court to take the feed from the judiciary, and as soon as that becomes available, we'll be going there. But for now, we take another break here on Silvera Learns His Fate, CVM's special coverage of the sentencing of former Member of Parliament and politician Jolyan Silvera in the 2023 killing of his wife, Melissa. Stay with us.
Hi, I'm Landy. Welcome to NLA Connect, the National Land Agency's customer engagement platform. NLA Connect is a simple, user-friendly platform designed to help you share your feedback, get support, and updates about land-related matters. Available 24/7, NLA Connect allows you to share suggestions, comments, and commendations, submit queries and report issues, attach files with your requests, track requests and get real-time status updates, connect with NLA client engagement officers, and provide feedback on the service received by the platform. We're making it easier for you to connect with us. You can access NLA Connect via our website, using the kiosk at any of our offices, or scanning the QR code displayed at our locations. Need any help along the way? Check out our FAQs section. It has all the answers you need in one location. NLA Connect, your voice, our priority.
Ready, tech, grow! Business is fast, easy, flexible, and costs less. Oh, entrepreneurs, let's go digital! The government of Jamaica and the European Union present Digital Jamaica Training Series. Learn how technology grows your business. Choose the right digital tools. Manage your staff, customers, and money digitally. Data security and privacy. Artificial intelligence. We'll be in every parish. Apply online. www.jbdc.net. Log on fast. Digital Jamaica. Powering connectivity for MSMEs.
Welcome back. I'm Giovanni Dennis. Thanks for joining us here on CVM TV for Silvera Learns His Fate, or special coverage of the sentencing of former Member of Parliament and businessman Jolyan Silvera for the 2023 killing of his wife, Melissa. We are now joined on Zoom by Senior Attorney at Law, Bert Samuels. Mr. Samuels, good morning, and thank you so much for joining us here on CVM TV.
Good to be with you and your listeners, your viewers.
Mr. Samuels, you have been speaking with us here on CVM TV in the build-up to today. You've been given human service. You've been speaking with our reporter, senior reporter Nicole Lewis, about this matter. And you spoke as well when he pleaded guilty and it was accepted by the Crown. And you gave some factors because, of course, members of the public were upset at the time and saying, you know, why not go to trial with this thing so that the man can get more time? And people were very skeptical about that manslaughter plea and the acceptance of that plea. Could you just remind our viewers about the considerations that you mentioned, a real world and an ideal circumstances? What are the considerations why this manslaughter plea would have been accepted, just to kind of bring some of our viewers back up to speed?
Well, I'd like to start with the concern of the public. Go to trial so he could get more time. And in the practical world, the maximum sentence is life for manslaughter. So if the public is concerned about too short a time because the manslaughter plea and the law in relation to manslaughter doesn't allow the judge to give enough time, that's the highest sentence apart from hanging that you can get. It's life imprisonment. So it still gives the court a latitude to give a sentence which the public may say, this is the sentence that I think fits that crime. So as an attorney, I'm not so concerned about whether it's manslaughter or whether he goes to trial on murder, because ultimately the maximum sentence is life. So 6 of one, half dozen of the other.
And speaking of that as well, and myself and attorney at law Alexander Shaw, we were speaking earlier about the firearm felony as well. That also brings with it some mandatory minimum time. It has a maximum of 25 years. Could you speak to that a bit as well in terms of the public's concern about the time that Silvera will get in behind bars?
All right, so, you know, if you were in school, I would say take out your pencil and paper, because if the starting point is the lesser offense, that is, you know, a felony with an unlawful weapon, that is the shooting and creating death, that's the use of the firearm to commit a felony. Even if she did not die, that section will kick in. So the starting point, because the prosecution has leveled 2 charges. One, it is the use of the firearm to commit a felony, and 2, it is murder reduced to manslaughter. So in terms of sentence, the judge's starting point must be the minimum sentence of the 25 years that you're saying. My checks was that it was 20, but I will verify that shortly. So the starting point for the judge in this matter is the minimum, which is 25. So he can only go upwards from 25 and impose the sentence for manslaughter. So he'll be passing possibly 2 sentences, 2 custodial sentences. Now, the next debate is whether they will run concurrently or they will run consecutively. Maybe you want to discuss that.
Yeah, we will come to that a little bit, and we'll explain that I remember in my research, Alexander Shaw, in an instance like this, as Mr. Samuels just mentioned, concurrently or one after the other, because it's a commission of it's one incident, it's one act, the sentences will run concurrently, even though he's charged on 2 separate matters. Explain why that's the case in our jurisdiction.
No, it's not the case. It's not necessarily the case. The judge has a discretion to make sentences run consecutively. So it's not my view that because it is one enterprise, it's a thing that the judge's hands are tied to make them run together. My view is that the judge can say that they will run so he'd send for sentence A and then do time for sentence separately. But the convention is, it is only in rare circumstances that a judge will ask that the sentences run concurrently, consecutively rather. And that usually is in some cases where both sentences are, in the view of the court, too low. So to put them together and serve them separately would do justice in the case. I hardly think that there'll be a consecutive sentence passed in this matter. I do think it will be for concurrently.
Yeah, and why is that, Alexander Shaw?
Well, as I think, as Bert said, if it is that the judge is of the view that when he the overall punishment doesn't fit the crime, perhaps that in that instance he may ask the sentences to be run consecutively. But I do believe in an instance where, for example, 20 years, a minimum of 20 years, that is sufficient. We're talking about a manslaughter offense here, and that I believe is appropriate. So I don't see the Chief Justice stepping outside of the convention of concurrent sentencing.
Yeah.
It's rare that he will actually do that, and it's only if he believes, okay, when I allow both sentences to run concurrently, it will not fit the crime. In this case, I think it will fit the crime.
Just to give our viewers an update in terms of what's happening right now in court, on the floor is his defense counsel, Peter Champagny. Champagny has said that Silvera has accepted responsibility and that is big. He says that Silvera's actions were not premeditated. And I think this is an important point, because this may have also been one of the reasons why the prosecution accepted the guilty plea Alexander Shaw, because there's no way you could go in his mind, in his state of mind, to say this was premeditated, and he has said it was provoked. How much of a consideration is this? Because there's no way to argue this differently if it is that the prosecution had decided to go to trial.
Well, and that is why the defense is one of provocation. It is the sudden loss of self-control. But well, he was, because usually the court would take into consideration if the accused is armed with a weapon, but he's already the owner of a licensed firearm. So that is something. But where was the firearm? And premeditation doesn't necessarily mean that it has to be planned 1-2 hours before. Just mere seconds before the offense was committed can amount to premeditation. So I don't necessarily agree that there wasn't premeditation. Because the charge was one of murder, and with manslaughter, it doesn't mean that there is no premeditation. It just takes a different form, which is the mitigating factor of provocation that brings it or converts the murder to that of manslaughter. So mere seconds are enough.
Any thoughts on that, Mr. Samuels?
Yes, yes. If you leave the room and rush to another place in your vault and go for the firearm, there's enough time separating your anger from committing the offense for it to say it is premeditated. Yes, it has to be on the spur of the moment without any lapse or break in time. I agree with counsel. But I wanted to go to another issue because the prosecution has confessed, and rightly so, that they have no witness to the murder, to the killing, and therefore it is his account that they will have to almost accept as to what triggered him, because this is a case, unlike some cases, there is no footage, video footage of what transpired just before he fired that fire. So in a way, and maybe the public is upset with this, the prosecution is almost compelled to listen to his explanation in the absence of any direct evidence to contradict him on that. And there is a case which says when the accused gives an account of the manner in which he committed an offense, unless the prosecution can rebut it, the judge must take it seriously into consideration and almost give it some preferential treatment.
Yeah, just to give another update to our viewers, Peter Champagne has said that the actions were spontaneous and resulted from what his wife said to him. And of course, he has said that, she accused him, she was very critical of his presence in the death of their child a few years ago. He has said that he admits that the actions, an aggravating factor was that he left the body for the kids to find. Mr. Champagne is saying, yes, this is in fact an aggravating factor. He says some may say that Silvera's admission of guilt was late, but Mr. Champagne is asking the judge to consider that Silvera said he didn't want the children to lose both mother and father. He's also quoting from cases to suggest a lower sentence. This is Mr. Champagne right now, still speaking. Again, our viewers, this is exactly what's happening in court. He also says the social inquiry report says there is a low risk of harm from Silvera to himself or society. He's now talking about a discount and that he could get a 35% discount, but says it is for the judge, that's Chief Justice Brian Sykes, to decide. And he's now talking about using the firearm to commit a felony. So these are the arguments that Peter Champagne is making in his plea mitigation at the moment. We spoke earlier about this Alexander Shaw, the discount. Here is Peter Champagne saying that he could get a 35% discount based on what he has said. Your thoughts on that?
Well, yes, because as we were saying earlier, an earlier plea may have afforded him a 50% discount, but notwithstanding that, the very fact that he did not go to trial and contest the issues, then he should be discounted for that. And I think even though he has not said it, time spent is also a factor that the court will take into consideration.
Right. Any thoughts on that, on this fact, on this here, Bert Samuels, the discount, the sentencing discount that Peter Champagne is speaking about here, asking for up to a 35% discount, saying, yes, it's for the judge to consider. Your thoughts on that?
Yeah, because once the client has pleaded guilty, it becomes the beneficiary of conventionally of that 35% discount. And the rule is that the person is not, wasting the court's time. A trial like Mr. Silvera could go into 6 weeks. So rather than 6 weeks, he's getting the court's attention for 1 day. And there's some reward for that. Also, the question is, it encourages others to take that route. So when one person pleads guilty, he gets a discount because he's demonstrating to other accused, follow me, and we'll save the backlog in the court system, and it encourages others to take the same route. So yes, that discount is definitely there. But the time spent, which I gather there was a tally of that count, I think it's somewhere neighboring on 3 years, 2.5 years. He must give him a discount for that. The judge has no discretion. He must demonstrate that he has given back that time and has reduced what he was intended to, the sentence he was intended to give, and discounted by the time that he has already spent in custody. The law is that the judge must do that.
Yeah, Peter Champagne has said that the law to put the court in a straitjacket, but says that the court can go below the statutory minimum. He has cited one case, Cecil Moore, where the Court of Appeal went below because of the time he had spent in custody. The judge referred to a case and said that you can see why the public raises questions about judges, because in that case the man had a previous conviction and only got 9 years. The judge has said that in some Caribbean countries, they categorize manslaughter, example, if committed with a firearm, that would be treated most seriously. This, though, is interesting. Mr. Champagne is saying that the court can go below the statutory minimum. How does that align with what Bert Samuels was just saying just now in terms of the time served and that having to be considered?
Well, I perhaps would have to, because the court, or what the authorities have said, is that the judge doesn't have to, allow the sentencing guidelines to place it into a straitjacket. And I would want to think he's actually talking about the sentencing guidelines. But if the legislation gives a minimum, I don't know that the court can actually go outside of that. Senior counsel?
Mr. Samuels?
Yes, I'm hearing you. Go ahead.
Right. So I just want some clarity for this part here. Judge has said that, well, it has been said that in some countries they divide manslaughter into voluntary and involuntary manslaughter. Could you break that down for our viewers?
Oh, yeah, that is true. So, for example, if your motor car meets in a serious accident and 2 persons die, that is involuntary manslaughter. That's a category of which that is why the sentence for manslaughter can be a fine. Because it's a wide-ranging set of circumstances called manslaughter. So the involuntary is really where you're driving your car, as opposed to you drive it and run down a person and hit them. That could be murder. So yeah, the involuntary is more likely and best explained by motor vehicle accidents causing death.
Let's go then. We're going to take another break here on Silvera Learns His Fate, CVM's special coverage of the sentencing of former politician and businessman Jolyan Silvera in the 2023 killing of his wife Melissa at their home. When we come back, we'll be going through the timeline of how did we get here. Stay with us. We'll be right back.
What a guan?
That a guan pa.
What a guan?
What a guan?
What a guan? Mondays, Wednesdays, and Fridays at 8 a.m., 1:30 p.m., and 10 p.m. on CVM TV.
That a guan pa. What a guan?
Let's delve deep into the issues. We'll take you beneath the surface.
Greetings and salutations. My name is Orville Higgins, and it's another edition of Fan Central.
Talking to the people at the heart of the top sporting stories. Hear from your favorite sportsmen and women and the administrators who work tirelessly to make it all happen. It's live sports talk.
I've written an entire article.
Yeah.
Looking at all the major issues every Tuesday at 9 p.m. It's Fan Central.
The internationally acclaimed On Stage with Winfred Williams.
At a new time, Saturdays at 8 p.m. on CVM TV.
So much more than entertainment.
Tune in to Lead Story. Weekdays at 6 p.m. Hosted by Jolyan Quarry.
Brought to you by Horizon, a new loan product from Access Financial Services.
Welcome back to Silvera Learns His Fate, CVM's special coverage of the sentencing of a former Member of Parliament, Jolyan Silvera, who is also a businessman in the 2023 killing of his wife, Melissa. Now, let's go through a timeline of how we got here in this matter. We're just going to bring up some graphics on screen for you to see how we got here. Now, November 10, 2023, Melissa Silvera, 42 years old, was found dead at the couple's home in Stony Hill. December 2023, autopsy revealed that Melissa died from gunshot wounds. Of course, it was initially suggested she died in her sleep and of natural causes. Now, when this autopsy found she died from gunshot wounds, triggering a murder investigation. In January 2024, Silvera was arrested and charged with murder. In May 2024, Silvera's application for bail was delayed and ultimately refused. So since he was arrested in January 2024, he has not been released. In February 2025, the court set a trial date for early 2026. January 12, 2026, the trial scheduled to begin. It was adjourned to allow for the examination of critical ballistic evidence. February 2, 2026, Silvera pleaded guilty to manslaughter, and that date is significant. Of course, our expert attorneys here with us have explained why, and we will go to that just in case you're just joining us. February 5, 2026, the Chief Justice accepts the manslaughter plea. And that, for now, is how we have gotten here. So it was accepted in February. It's now just about a month later after it was accepted. here we are, his sentencing today. Let's just kind of give our viewers as well an update in terms of what's happening in court right now. We should say to you that Peter Champagne, the defense counsel for Jolyan Silvera, has ended his plea mitigation, and his plea mitigation, in case you're just joining us, is where the defense counsel pretty much explains why his client should get a reduced sentence. He'll be giving all the mitigating factors. He'll also mention the aggravating factors, but try to explain why the mitigating factors perhaps outweighs those and why his client should get a reduced sentence. Let's also know say that, so before the break, Bert Samuel spoke about voluntary and involuntary manslaughter. Voluntary manslaughter would be a more serious offense than involuntary manslaughter. Before we move on right here, Alexander Shaw, explain why that is for our viewers.
Well, with voluntary manslaughter, so because manslaughter is the lesser of the two, murder and manslaughter. So murder, there is the intention to kill and the killing. And that is, the intention is the distinguishing factor between murder and manslaughter. Because in both instances, there is a killing. Somebody died. For voluntary manslaughter, there is also the intention, but because of some mitigating factor, be it provocation, diminished responsibility, or what we call a suicide pact. Involuntary manslaughter is what Bert spoke about earlier in terms of perhaps an accidental killing, or but the voluntariness of the manslaughter is what really makes it, or will attract a much higher sentence, because the law allows for a fine or a non-custodial sentence. I don't see that happening in this type of voluntary manslaughter case.
Yeah, the prosecution is now speaking, just to update our viewers, and of course, as soon as the stream becomes available, we will be joining the judiciary live for the sentencing of Jolyan Silvera. Now, the prosecution is talking about the discount possibly in law and is asking the judge to look at the language, saying that the court may reduce the sentence by up to 35 years. It's asking the court to look at the factors to consider in calculating the discount. Would the public conscience be shocked? What would shock the public conscience? Bert Samuels, speak to us about this shocking of the public conscience. What does this mean, and what are the considerations for this?
Shocking of the public conscience is the nature of the offense, and whether we have on record or the judge is going to give an appropriate sentence. So the conscience of the nation is rocked by maybe the fact that she was at her home, and kids were there. So there are the aggravating factors that makes it a shock. So when it is shocking, the court must rise up and do what it must do so that it fits the crime. It's an emotional statement, but it's nonetheless a factor in sentencing of accused persons for crimes which are, as it were, horrendous.
Yeah, the prosecution here is clearly making the point that, look, don't take off too much off of the sentence even though he plead guilty because of these aggravating factors and how this may shock the public conscience. Your thought on that and the prosecution raising this point right here, Mr. Shaw?
And as I've said earlier, Jay, is that we have already seen why, well, at least one demonstration. And so what...
I think there were two. There were one in Kingston and one in Montego Bay at the same time, yes.
And the call on the judiciary is that the sentencing or the sentence must fit the crime. And so even because the acceptance of the guilty plea for manslaughter was one which aggravated or angered the public. And so what they're asking for is for the judge not to go too low, because if the judge were to go too low in sentencing, then we are hearing all sorts of stories and arguments as to why it was accepted, albeit not true. The court now has an opportunity to do justice on both ends, taking into consideration the man in the dock and the victim and its impact, the victim's impact statement and so forth.
Yeah, this is very important, and we did play earlier a report from that protest that our reporter, who is now in court, Kevin Black, had done earlier this week. It was carried on Wednesday. We want to go back to that report in case some of our viewers are just joining us, because Alexander Shaw made a reference to the protest, and I do want a comment from Bert Samuels on this, but I do want Mr. Samuels to be able to view what the members at that protest were saying. That protest earlier this week that our reporter Kevin Black covered, that one that took place at Emancipation Park. We played it earlier, and we will be going back to that momentarily as soon as we can locate that, just to also update you and to say to you what is happening in court at the moment. The plea mitigation has been completed by defense counsel Peter Champagny, and the prosecution is now speaking and asking the judge to consider the factors in calculating the discount that the Chief Justice Brian Sykes will ultimately come to. Would the public conscience be shocked, for example, if the discount is too much? And they have asked the judge to look at the circumstances. I do want both my expert attorneys here, that's Alexander Shaw and Bert Samuels on Zoom, to speak about the circumstances of this case in detail for our viewers. But before that, we want to go back to this package that our reporter Kevin Black had done outside Emancipation Park, where a peaceful protest was staged by friends and family members of Melissa Silvera. Let's go to that report.
A myriad of people came out at Emancipation Park on Tuesday following the gruesome 2023 death of Melissa Silvera. Well-wishers, family members, and other participants came out pleading for the lessening of violence towards women, as well as to provide support to the family. CVM News was on location, and these are some of the people we spoke to.
Well, as a concerned Jamaican citizen, I heard about the protests, and I decided that it's time I came out and let my voice be heard, because it's an important issue that faces a lot of the women and the children in the society.
And so we're not going to have it. There is no way that we can go from chemistry class and the canteen and chatting and sitting on the ground in our immaculate uniforms and then moving to one of us is horrifically killed.
For Melissa Silvera, which is my best friend. And it's because of as everybody knows, that her husband killed her. And so we're here protesting that provocation is no justification.
The sentencing of former PMP MP Jolyan Silvera is reportedly set to take place on Friday, March 6. I am Kevin Black reporting for CVM News.
Bert Samuels, how, if at all, will the Chief Justice consider, incidents like a protest like that, for example, and some of the public reaction to this in coming to his decision that we expect in short order?
Well, I could put my defense hat on to answer that. I would tell the judge he should not be mindful about what is being said by persons outside, because the public does not have all the facts very often. The public is being very emotional. At the risk of being criticized for this, part of the circumstances, as I understand it, is that Mr. Silvera lost his son, who was left in his care. So he has been through that trauma. And, it is interesting to see how the defense would have said how it put him in a state of depression, because he was being, blamed for this by his wife, and rightly so. It's her child was left in his care, and I gather he's saying that issue was never resolved, and what led ultimately for the loss of control on his part. So that's a huge factor for the judge to put in the balance, because he has to put favorable points and unfavorable points. And therefore, you've asked me what the public's opinion is. Yes, the judge should turn a blind eye to it. It should influence him dramatically. He has enough persons in his courtroom to outline, which is the prosecution, enough of the circumstances, the aggravating circumstances. So it is the prosecution's outline with the witness The victims, for want of a better word, the victim here is his wife, but the relatives would have been able to put in, letters to the judge saying how it has affected them. It is what is before the judge in the court that it should be weighed by, and not by what the public is saying.
Yeah. Any thoughts on that?
Well, I agree with Counsel in that, because, and I think I said it earlier, that the authority says that the judge must consider the person who is before him, the man in the dock.
Mm. You had a similar case like this some time ago, Mr. Shaw. Give us a little bit of information in terms of the kind of arguments that you, as defense counsel, would be putting forward in a matter like this.
Well, the mitigating factors, age, which I think perhaps...
that goes against him in this one, because the judge will be saying, he's a mature person, 52, him should know better.
The weapon that was used, because in that case, a knife was used as opposed to a gun. And it wasn't something said that angered or caused the accused to have lost his temper, but something that was done.
And this is in your case. Could you just remind our viewers of that matter?
That's the case of the Queen against Romario Brown, where the accused lost self-control after sexual advances were actually made at him, and he killed the deceased. So,
and who was the deceased in this instance?
The deceased was a prominent designer. His name is
Pottinger.
Dexter Pottinger. And there was an outcry as well. The public was calling for, much higher sentence, because in the end, the accused got 12 years. Yeah. It's a little different here, because even though a gun was used, we're talking about children. So there are children that are actually, that at some point they will need at least one parent. So yes, we're saying, well, boy, the children had to stumble upon the dead body, and that's bad. But a court has to take into consideration that it really can't deny children of both parents. And so we're talking about, family law coming here now. And part of the whole best interest of a child is the Convention on the Rights of a Child. And the court will have to consider those factors, even though it's actually in the criminal court. And I think that is what counsel for the accused, Mr. Champagne, was doing when he was urging the court to consider that he needs to actually go home to his children at some point in time.
Yeah, and just to kind of remind our viewers in terms of the update so far, what has taken place in court since this morning, that's the sentencing hearing for Jolyan Silvera. The sentencing process, essentially, the social inquiry report and antecedent report, the plea mitigation that has been done by Peter Champagne, the prosecution submissions, which is currently happening. Character witnesses, they have also spoken on the aggravating factors, mitigating factors, the starting point, the discount, and we've been discussing some of these, myself, attorney at law Alexander Shaw, and on Zoom Bert Samuels. Now several family members are currently in court. The prosecution and defense agreed to take the social inquiry report and antecedent report as read, meaning they didn't call them into question. There was no doubt if this man has good character, he has not been charged with anything before. All of those were taken as submitted. The Crown filed written submissions and 4 victim impact statements, and the defense brought 3 witnesses. One of the witnesses said that he has known Silvera for over 2 decades and that Silvera has 6 kids and is a good father. Said that he has never seen him angry, and that before he gets angry, he would walk away, and that he was surprised and shocked at the charges because that is not the man he knows. Other witnesses have also spoken. Just to say to you as well that Peter Champagne has completed, and Peter Champagne is the defense counsel for Jolyan Silvera. in his presentation, he highlighted issues for the judge to consider. He mentioned the fact that Mr. Silvera had no previous convictions, that he has been in custody for 2 years, 1 month and 11 days. And of course, this has to be considered when the sentence is handed down, to be deducted essentially from whatever the sentence, let's say, is given 20 years, for example, it has to be deducted from that 20 years, the time spent in custody already. And of course, he has been in custody since 2024. No witness suggested that Mr. Silvera has a violent streak and that he has given service to the community both as a councillor and subsequently as a member of parliament. Of course, he was a member of parliament in St. Mary for the People's National Party. Champagne admitted that the circumstances of the case are in fact disturbing, but said that Silvera did the honorable thing and pleaded guilty, and that spared the witnesses and the children especially of having to go through a trial. Now, he quoted from the Social Inquiry report and noted that Silvera has accepted responsibility and that is a big matter to be considered. He said that Silvera has expressed remorse. How important is it, and I want to get reactions from both of you, starting with you, Bert Samuels, that the Mr. Silvera, the remorse factor here, how important is this? I think if you're okay, I'm sorry, Mr. Samuels. When you began speaking, you were muted. We didn't hear you. Just could you just begin? Yeah.
Very often during sentencing, a judge will say, "We have noted that the accused, when he was interviewed by the social inquiry officer, did not display any kind of sorrow or regrets about what happened," and that's a aggravating factor. So the judge will increase your sentence if you do not show any remorse. Now, interestingly, where you plead guilty, it's difficult to see a person who has taken responsibility not demonstrating remorse. So I think here Silvera in the report has said that he did say he was very sorry for what has happened. So that's a factor in his favor for a sentence reduction.
Alexander Shaw?
I agree with counsel, because I think ultimately what counsel is trying to do here, even in terms of, because you spoke earlier about the mandatory minimum, and I think he's trying to move the court, or he was trying to move the court to go below that in a very technical way, because if the court believes that the mandatory minimum is too harsh, then the judge could always issue a certificate so that, you know, he could actually go to the Court of Appeal to, you know, to get a reduced sentence. But technically speaking, unless it's a case where he was asking the court to consider time spent, and in so doing, it would go below the 15 or the 20-year mandatory minimum. But I think, albeit, what the real challenge for the judge is how does he balance what the Crown is saying as opposed to somebody who is, although he's a very mature person, he has been a very decent, law-abiding person who has offered so much to his community. So even though he's not young, and you know, and because we see young people as ones who are prone to make certain mistakes, and you're expecting much more from a mature person, but he has led a very good life, and that is ultimately what provocation is about, losing self-control. So it's clearly that this is not somebody who gets up and is violent every day, and by virtue of that, you should, you know, try to lock him away forever.
All right. I should say as well, so in addition to the fact that Champagne said that, you know, Silvera has expressed remorse, he said that his actions were not premeditated. He said his actions were spontaneous and resulted from what she said to him. And of course, Bert Samuel spoke about that earlier. She blamed him for the loss of their son who died, who drowned. Peter Champagne admitted that that an aggravating factor was that he left the body for the kids to find. I want to get comments from both of you on this as well, starting with you this time, Alexander Shaw. Aggravating factor, he left the body for the kids to find. How will this factor in?
Well, because even though he shot her, who knows, maybe if he had sought some medical attention, perhaps she could have been alive now. So assisting the police, the ultimate measurement is whether you assist the police. And assisting the police could start from the very beginning, the seconds after the offense, or even, admitting to what really happened from the onset, which
Stick
never
a pin
happened.
right there.
Yes.
And let's bring in Bert Samuels in this, assisting the police. So yes, he has pleaded guilty here, Bert Samuels, but did he assist the police initially? And that's an aggravating factor, because the public was led to believe that Melissa Silvera died of natural causes until the autopsy came about.
Yeah, that doesn't go in his favor at all. It's a real aggravating factor, because he was himself mourning about her death, went to her funeral and was distraught. And so the public was of the view that she died of natural causes. The shock that you referred to before was when it turned out that the ballistic certificate following the post-mortem, that it came from his firearm, not only shocked the public, but caused him to change his mind about fighting this case. And it caused him to be charged, really. And the complexion of the case changed totally against him. And that's the fallout that we're witnessing now for someone who virtually could be said to be deceiving the public and deceiving his children and everyone, only taking this course of action because there is scientific evidence linking his firearm to those bullets found in her body. Yeah. And it's not just one. That's a big point. Yeah. Whenever a person is reacting to an attack or from a provocation, if you make one blow, you're in the best position. But if you give 3 shots, that's aggravating.
And let me just add to that as well, just in terms of some breaking news coming out of the courts right now. The prosecutor also said that he is asking the judge to take into consideration the overwhelming aggravating factors, that the killing was done with a licensed firearm, that the killing was done in the home shared with the kids, that the body was left for the kids to find, that he did not tell the truth initially about how she died. So at the first instance, he did not tell the truth, that the victim impact statement have shown how the kids have been affected. So this is the victim impact statements. I do want comments from both of you on this, but I'm withholding that just for a moment, so just for you to consider. And that they had to be in counseling after finding their mom, and that he retiled the room and painted and sprayed furniture in the aftermath. This is somebody attempting to hide. This is what the prosecution is here saying, attempting to hide what has happened here. Just to say as an update as well, and this is an item of breaking news, that the judge has left the court and says he will return in about 20 minutes. He said that about 8 minutes ago. And so the judge in just a little over 10 minutes will return. And once Chief Justice Brian Sykes returns, we will be going live to the Supreme Court in downtown Kingston to get his comments live. They have announced, he said at a recent media day, Chief Justice Sykes, that the sentencing will be live streamed for the public to be able to hear what is happening. Let's get some reaction. So we're just about 10 minutes away from that, 10 or 12 minutes away from that, Alexander Shaw, Bert Samuels. But before that, listening now to these comments from the prosecution, he did not tell the truth initially about how she died. The victim impact statements have shown how the kids have been affected, that they've had to be in counseling after finding their mom, that he retiled the room and painted and sprayed the furniture. Your reactions to these points being brought by the prosecution? Let's start with you, Bert Samuels.
Yeah, that's kind of very awful, a very sad set of facts, because you're trying to conceal a crime, and that in itself is an offense. Even if he did not commit it himself, the concealment of a crime can be seen as an offense in law. So it's very difficult to come out of that web. You know, his legs are tied by that conduct, and it's something the judge cannot turn a blind eye to. And we have to commend the investigators in this matter that they uncovered what seemed to have been an attempt to cover up this offense and to have used scientific evidence. You know, we encourage investigators to rely more in our courts on scientific evidence, which when it's brought before, it forces a lot of accused to do the right thing. And scientific evidence can exclude a suspect, or it can include a suspect. And that is why we encourage the use of scientific evidence. And this is scientific evidence on show, you know?
Yeah, victim impact statements, counseling for after finding their mom for the children, room retiled and painted and sprayed furniture. Alexander Shaw.
Well, the truth is that, as Bert said, is a crime. But when you look, and I think the judge will give some attention to it, but nobody wants to go to prison. And so even with that, he's still entitled to all the discounts and the mitigating factors. So those are things that will ultimately push the sentencing up. But he can't wiggle out of that. So there is no room for negotiation there, simply because of how it was done. And as Bert said, it's, the police had to uncover this by themselves. And so it begs the question then, in terms of remorse, is that really a slap in the face when he says that, well, I was remorseful, or his counsel said he was remorseful? But I think the judge, very, very prudently will try to see how best he can balance the scales of justice.
Yeah. All right. Just to say to our viewers, we're on a countdown right now. About just under 9 minutes to the live stream to begin. We will be taking a quick break here on Silvera Learns His Fate, CVM's special coverage of the sentencing of former Member of Parliament Jolyan Silvera in the 2023 killing of his wife Melissa. When we come back from this short break, we will be hearing from Kevin Black, our reporter, who is in court. He is at the Supreme Court in downtown Kingston and just filed a report, and we'll be hearing the very latest from him. So stay with us here on CVM TV as we continue to track this sentencing of Jolyan Silvera. We'll be right back.
Headed straight in your direction, 'cause I'm
a guan.
That's a guan, pa.
What a guan.
What a one! Mondays, Wednesdays, and Fridays at 8 a.m., 1:30 p.m., and 10 p.m. on CVM TV.
And that's a guan, pa. What a guan.
Welcome back to Silvera Learns His Sentence. This is CVM's special coverage of the sentencing of former Member of Parliament and businessman Jolyan Silvera in the November 2023 killing of his wife Melissa. Now, before the break, we promised you an update from our reporter Kevin Black, who is in the Supreme Court in downtown Kingston. And let's go now to this report from Kevin Black, who stepped out to give us the report. Of course, there can be no recording inside the actual courtroom, and the phones have to be on silent. But of course, we have been, getting updates in terms of what's happening. Let's go to Kevin Black.
Upon entering the Supreme Court this morning, the atmosphere was rather somber and serious, as everybody inside was patiently awaiting the sentencing of what will possibly go down as one of Jamaica's most historic court cases. It involves ex-PNP MP Jolyan Silvera, who killed his wife in 2023. Now, CVM News understands that his legal counsel, who is Peter Champagne, is appealing for a merciful sentence, as he said to Chief Justice Brian Sykes that he hopes that Silvera will be able to see the light of day again outside the confines of a prison in whatever sentence he receives. Now, CVM News has been tracking the story and will continue to do so throughout the course of the day. But until then, I am Kevin Black, reporting for CVM News. Back to you in studio.
All right, thanks so much, Kevin Black, our reporter, who is downtown Kingston, just outside the Supreme Court, giving us that report. He has now made his way back inside the courtroom, and just want to share this timer with you so you're not getting my opinion on how soon the live stream will begin. We are just over 4 minutes away from the live stream. Chief Justice Brian Sykes at about 11:28 or thereabouts noted that he would be back in about 20 minutes thereabouts to make his comments on this matter before he does his sentence, and so we are awaiting that. One of the factors that has angered the public in many ways, Bert Samuels and Alexander Shaw, is the discount. And just to share some of the comments coming from our viewers who are following our stream on YouTube, they have, in commenting on this matter of the discount, Goodness Running After Me has said that, what discount? The courts must stop this discount option. This is not a sale transaction. People's lives are at stake. Not everyone likes this discount offered when a guilty plea is made. But what's your response to that? Firstly,
well, the court has to follow the law, and there is a reason for guilty pleas or the Criminal Justice and Administration Act. In fact, in a number of jurisdictions, we don't even have that many trials as in Jamaica, because you would want to ensure that you don't have lengthy trials, because it's going to be very costly. It's very costly to actually, do a trial, be it for the accused person, even for the state. And so the law is there to ensure that we get matters out of the court, because when the court is backlogged with matters, people really can't get justice. So I understand in this particular case why some persons would be upset because of this whole discount argument, but it's there for a reason, and it has assisted the public, because sometimes it's very difficult for the prosecution to get eyewitnesses to speak to what happened. And even in those cases, if somebody decides to tell what happened, then that person has to be discounted.
Yeah. Bert Samuels, not many people...
Yeah, I agree totally with my friend's opinion. The public must be aware of the fact that where a person is waiting trial for too long a time, that can be a ground of appeal, that is delayed. The law is that if your trial is delayed beyond a certain amount of time, an appeal court can acquit you based on the delay alone. And so we see matters going to the Court of Appeal in Jamaica and the Privy Council. One of the strong grounds is the person has been awaiting trial. For example, in that well-known case of Vibes Cartel, that's one of the grounds on which no retrial was ordered, that the men had been in custody for 13 years already, and to continue with the trial or asking for a retrial was not in the interest of justice. So the public has to be aware of the principles of law, that persons who plead guilty should be given discounts to encourage others to plead guilty so that we can get rid of this horrendous backlog in the system.
Yeah. I want to get from both of you before we go. We're getting closer now to the comments from the Chief Justice, which will be broadcast by the judiciary. And of course, we will be going straight to the live stream from the Supreme Court in downtown Kingston as soon as that happens. I see Mr. Samuels getting up from his seat. Mr. Samuels, please come back. I want to get your opinion in terms of how long are you expecting? What sentence are you expecting? Let me start with you first, Alexander Shaw. Putting you in the hot seat, what are you predicting? And give me a reason for your answer.
And I'm going to do just that. Chief Justice Simmons, in a similar case, he said that in a contested trial where death was caused by a firearm and the facts are grave but mitigating factors such as provocation exist, the range of sentence should be 18 to 22 years. However, an early plea of guilty in a non-contested case on similar facts will attract a lower sentence in the range of 14 to 18 years. And so I am there with the Chief Justice. I believe 18 to 25 years. I don't see the court going beyond 25 years because...
Sorry, you mentioned in the non-contested one. Just go back through the time that was said there by Chief Justice Simmons.
He said that in a non-contested case on similar facts, and that is the use of a firearm, and there are mitigating factors such as provocation, it will attract a lower sentence in the range of 14 to 18 years. The difference, yes.
What about the mandatory minimum
for the firearm
charge?
So that is why I am pushing it out of... So that is for the manslaughter offense. But for the firearm, I see it going up to, say, 25 years because the minimum is 20 years. I don't see the court going too far beyond that because persons have gotten 25 years in a contested trial. So in a non-contested trial where the person has pleaded guilty, and the defense is that of provocation, going beyond 25 years, I think may open the door for a challenge if the court, were to so do.
Yeah. Garfield on our live stream, Garfield Leslie saying he wants 150 years. I will not say what he said after that. Let's come to you, Bert Samuels, for your thoughts on this. What's your prediction in terms of sentencing, and give me a reason for your thinking if you care to share.
Okay, fine. I've never done this before, but because you've invited me, let me say the starting point could be 30. And then the judge would say, I have to discount it by time spent. So I have to give him back his 2.5 years. And therefore, the sentence would be 27 years.
So you're predicting 27, and you're predicting what exactly?
25, the maximum.
25, 27, not too far apart. What about the mitigating factors then?
Well, I do believe the mitigating factors are what will actually bring us down, because even though they're the aggravating factors, I would imagine, are what Counsel Bert Samuel would have used to, cause him to start at 30 years. So the mitigating factors, and there are a lot of mitigating factors, even though we have been focusing on the aggravating factors, there are a lot in his favor because he acted he lost self-control, and provocation by itself is a mitigating factor.
Yeah. We will take another short break at the moment. Hopefully by the time we come back, the Chief Justice Brian Sykes will make his way back into the courtroom, and we will be able to join them to get that stream. We'll also be giving you a special edition of our midday news to cover this. So as soon as that comes up, we will be going and take the live stream from the judiciary, and then we'll give you the rest of the news thereafter. But we take a break here on Silvera Learns His Fate. Any moment now, we're expecting the Chief Justice to come back, and then we will go over for that stream from the Supreme Court in downtown Kingston. I'm Giovanni Dennis. Thank you so much for staying with us. We'll be right back.
Let's delve deep into the issues. We'll take you beneath the surface.
Greetings and salutations. My name is Orville Higgins, and it's another edition of Fan Central.
Talking to the people at the heart of the top sporting stories. Hear from your favorite sportsmen and women and the administrators who work tirelessly to make it all happen. It's live sports talk.
I've written an entire article.
Yes.
Looking at all the major issues every Tuesday at 9 p.m. It's Fan Central.
The internationally acclaimed On Stage with Winfred Williams.
At a new time, Saturdays at 8 p.m. on CVM TV.
So much more than entertainment.
Tune in to Lead Story. Weekdays at 6 p.m. Hosted by Jolyan Quarry. Brought to you by Horizon, a new loan product from Access Financial Services.
Every dream conquered is another dream gained. I land and I fly again like a jet plane. Headed straight in your direction, 'cause I'm wiser, one step closer. I'm winning 'cause I work so hard. And the music keeps on playing, and the people them I say we are my show tonight.
Let's delve deep into the issues. We'll take you beneath the surface.
Greetings and salutations. My name is Orville Higgins, and it's another edition of Fan Central.
Talking
of the king against Jolyan.
Welcome back. We're going straight to the Supreme Court. Chief Justice Brian Sykes is back. He is sitting looking at his laptop, and he is now beginning to speak. We're heading straight over now to the Supreme Court.
Okay, so it is about
charge him with the offense of murder, charge him
on
with the
the
offense
screen,
of particulars
and,
of that offense. Particulars of that
again, we are
offense
waiting.
are that Jolyan Silvera,
So we now
the night
turn
of
to
November 10th, between the night of November 10th and the morning of November 11th, and the morning of November 11th, in the parish of St. Andrew, Melissa Silvera. Melissa Silvera, to that count, he entered a plea of not guilty of murder, but guilty of manslaughter. The plea was accepted by the prosecution and accepted by the court. This plea was entered on February 3, 2026. And on that date, a statement from the defendant was read into the record. And it states, I, Jolyan Silvera, made this statement to say that on the night of November 10th, 2023, a very unfortunate incident occurred, resulting in the death of my wife, Melissa Walter Silvera. Leading up to that event, there has been provocation from her ever since the death of my son, for which she continues to blame me. As per usual, to avoid confrontation, these confrontations vary from financial to taking responsibility for the conditions that we were living in, and she has a time where she explodes no matter when and where. She became very physical that particular night. These are ongoing things. So at times, when I see that this is going to blow out of proportion, I normally take refuge, at my sister's house to allow her temper to quell. On this particular night, the rhetoric began. She became more confrontational than normal, screaming, shouting, and even at times swinging her fist. So I decided that it was time to leave. So I reached for my gun, where it is normally kept, to holster it, and told her that I would be back tomorrow. She became increasingly angered and enraged, and lunged after me and grabbed at the gun, and then uttered the words to the effect that I was responsible for the death of our child, and made derogatory comments about my mother and the family. Although she had mentioned blaming me for the death of my son before that night, the way she said it and how, and the mention of my mom and my other family, her words and expletives that night really angered me in the moment. Melissa told me I must stop fucking my sister, because every night I'm always going to my sister's house, and a sister can't do what a wife can do. She said that my mother was a selfish fucking bitch, and maybe I should go and fuck her too. These words provoked me, and her final comments We're not fling the rest of the picnic them in the pool and kill them too. With all of these words, I lost control and fired. It was never my intention to do this. It was not premeditated, and it was not my intention to hurt or kill her that night. This having happened, I panicked and I left. Over the course of the next few days, I thought about my children losing two parents and thought it best not to admit because I wanted to be there for them. And importantly, this statement, which I read over, consisting of what? 1 page, signed by me, Jolyan Silvera, is made of my own account. And it went on to indicate that it bore his signature and date and a witness who was not connected to the matter. So what we have then is a written statement in which he outlined in some detail the circumstances that unfolded on that unfortunate evening. Now let us go now to what the prosecution outlined to the court. And then we'll have some observations about that, and then put this in context of the law relating to homicide. Prosecution's narrative is this. Sometime after 10:30 p.m. on the 10th of November 2023, Mr. Silvera told his wife and children that he was leaving and that he will return the following day. His wife told him that he could not leave, and an argument ensued. According to the children, the adults swore at each other and then he left. Sometime before 6 a.m. on the morning of the 11th of November 2023, one of the children, and the name is there but I'm not calling the name, went into his parents' room. He discovered his mother's lifeless body on the floor next to her bed. He observed that blood was coming through, to quote, her butt, mouth, and nose. He ran from the bedroom and alerted his other brother, who accompanied him back to the parents' room. They indicated they both checked for signs of life. They then decided to make contact with their father and were eventually successful. The prosecution next referred to a witness statement provided by Mr. Silvera. This is a statement that was provided before he became a suspect. In that statement, he indicated that upon speaking to his children, he contacted the Stony Hill police station and told them that he was on his way home when he got a call from his son indicating that his mother's lifeless body was there and that he needed assistance. Upon arrival at the house at 28 Diamond Road, Stony Hill in the parish of St. Andrew, Mr. Silvera went into his bedroom, saw his wife sitting in a position with her head leaning forward at the side of the bed. According to witnesses, that is the children who were there, he touched her, spoke to her, and found that she was not responding. So up to that point, based upon this, you had the body, the children, then Mr. Silvera arriving, then you had Mr. Silvera, the body, and the children. Short while after, a first responder from the Jamaica Constabulary Force arrived, that is a sergeant from the Stony Hill Police Station. He went into the bedroom along with Mr. Silvera, where he, the police officer, saw the body of the deceased. The police officer described the body as being on her knees in a crouching position with her face lying on the floor. The police officer then took a photograph of the body, and whilst he did so, he says Mr. Silvera cried out. He told Mr. Silvera to cover the nude section of his wife's body. The police officer did not carry out any further examination of the body. The officer indicates that he did not, that Mr. Silvera advised him that the deceased had no known medical condition, and the police officer seems to be indicating that a post-mortem examination would be conducted to determine the cause of death. The House of Tranquility Funeral Home was contacted for the removal of the deceased body. Not clear from the narrative who did the contacting, but nonetheless, that was a contact that was made. The police officer says he then indicated that he told Mr. Silvera, do not do anything to the bedroom pending the post-mortem examination, as the cause of death was undetermined. Mrs. Silvera's body was removed and taken to the House of Tranquility Funeral Home. A post-mortem examination was scheduled for the 1st of December 2023. The pathologist who arrived to do the post-mortem examination observed marks on the body. As a result of her observation, the body was sealed and the detectives were called to assist in the investigation. So, on the 15th of December 2023, the same pathologist conducted post-mortem examination on the body of Mrs. Silvera. The pathologist noted that there were 3 gunshot wounds. 1 perforating gunshot wound to the front right thigh, 1 penetrating gunshot wound to the left side of the lower abdomen, and a 3rd that is described as a superficial penetrating gunshot wound to the right side of the lower abdomen. The pathologist found that the immediate cause of death was due to multiple gunshot wounds. During the post-mortem, the pathologist removed 2 projectiles from the body of Mrs. Silvera. These projectiles were handed over to an officer, not the one who turned up apparently on the 10th of November, assigned to the Jamaica Constabulary Force, and it was after the post-mortem was concluded, Mr. Silvera became a suspect and was taken into custody. The narrative goes on to indicate that he's a licensed firearm holder. Specifically, he has a 9mm Glock Model 17 Gen 4 double action auto-loading pistol, black polymer receiver slide, a 17 cartridge capacity magazine bearing the serial number AAFZ038, and this firearm was taken from him. The firearm was submitted to the Institute of Forensic Science and Legal Medicine for ballistic testing, along with the 2 projectiles removed from the body of the deceased. The ballistic examiner made a comparison. He test fired the gun. This is now in January of 2024. Test fired the gun. He took results from those test fires of January 2024 and compared it to the projectiles that were removed from the deceased body. He found what he called level 1 characteristics matching. That is, according to the narrative, the projectile came from a Glock pistol, the type of Glock that it would have come from. He found that there was some amount of level 2 matching, and this apparently is striations, and that there were no additional markings that were unusual. So I'll pause here for a moment and indicate this. In preparing for this matter, I was reading through the material, and I had sent questions to both counsel for the Crown and the defense through the Registrar of the Supreme Court to answer specific questions. I had used the incorrect expression. I think I used markings, level 1 markings are not matching. So counsel for the defense, being the cautious man that he is, he indicated that he did not have any document that referred to level 1 or level 2 markings. So that was my error. There should have been matching. The Crown also responded, getting assistance from Superintendent of Police Miguel Bernard, and he responded, and apparently this is a quotation from him. I don't think the defense is taking issue with the exposition on this by the superintendent. He says, correcting me, that the term used was level 1 matching and level 2 matching. The term is used to provide a simplified understanding of the examination process. Level 1 matching, this is matching of the class characteristics. Class characteristics can be used to eliminate certain firearms as potential sources of firing a bullet or a cartridge case. However, they do not narrow it down to one specific firearm in the class or group. Class characteristics of bullets include the caliber, the number of lands and grooves, direction of twist of lands and grooves, and width of the lands and grooves. It says in this case of the King against Jolyan Silvera, the class characteristics narrowed the source of the marks on the bullet to Glock pistols, which is a smaller group from all the potential make of firearms that exist. The accused firearm submitted as evidence in the case was a Glock pistol. Therefore, the examination progressed to level 2 examination. So what he seems to be saying is that the level 1 determines the class. And then once it falls, you identify the class, then you go on now to see about the specifics of the object, the gun. Level 2 matching, he says, is this. This is matching of the individual characteristics that are unique to one specific firearm. At this level, the comparison requires microscopic analysis and cannot be done with the naked eye. Individual characteristics of bullets are random, striated marks, striations on the land impressions on the bullets. In this case, the King against Jolyan Silvera, there was sufficient matching of the individual characteristics to conclude that the bullets matched the test fires said to be from the accused's licensed firearm. He says the damage seen in the barrel was consistent with a corrosive chemical reaction in the barrel, was unlikely to have occurred naturally because in the relatively short space of time between the death of the deceased Melissa Silvera and the gun being submitted to the ballistics department, this corrosion distorted the individual characteristics, making it difficult to match bullets fired through the barrel before the corrosion and those that were fired through the barrel after the corrosion. That is to say, the damage was consistent with or likely a deliberate attempt to prevent any subsequent matching of test fires from the gun with any bullets that were fired through the barrel prior to the corrosion. So we go back now to the narrative here. Yes, so he continues now. There is something called an IBIS system, that is an integrated ballistic identification system, commonly known as IBIS. This is a database, and this database contains firearm ballistic signatures. So how does this come about? Under the Firearm Prohibition, Restriction and Regulation Act that came into effect in 2022, roughly a year before this incident, Section 20 of the legislation sets out the responsibilities of what is called the Firearm Licensing Authority. Section 20, subsection 1 says, there shall be established for the purposes of this act a body to be known as the Firearm Licensing Authority, which shall be a body corporate to which Section 28 of the Interpretation Act applies. Section 20, subsection 3 states, the authority shall be responsible for regulating, in accordance with this act, the handling of firearms and ammunition, and the importation and exportation of firearms and ammunition into or from Jamaica, and without prejudice to the generality of the foregoing. The functions of the authority shall include, and it has an impressively long list, but for our purposes now, we come to paragraph L, which says that that is the Firearm Licensing Authority to conduct ballistic testing, capturing ballistic signatures in relation to privately owned firearms, and capturing related information with respect to firearms that are the subject of authorizations granted by the board. Then there is reference to Section 29, which speaks to the identification of firearms. And then there is Section 31, which says the institute shall be the responsible entity for capturing ballistic signatures and other information in relation to firearms that are the property of the government of Jamaica. And then Section 31, subsection 2 says the authority shall be the responsible entity for capturing ballistic signatures and other information relating to privately owned firearms. So that is the context in which this capturing of signatures of firearms take place. An institute is defined in the legislation as the Institute of Forensic Science and Legal Medicine. That's found in Section 2, that is the interpretation section of the statute that defines institute. So that is what is being referred to in the legislation at section 31. Right, so now, so the narrative goes on. The Firearm Licensing Authority apparently has access to this IBIS database. And apparently the idea is that whenever a person would acquire a firearm that's a private citizen and present the firearm to the Firearm Licensing Authority, test fires will be made and the ballistic signature from the said firearm is uploaded to the IBIS system. So the FLA creates a signature, is stored on the IBIS system. The expert goes on to say now that in January 2024, he took the test fires from Mr. Silvera's firearm and compared it to the ballistic signature that the FLA would have had based upon its statutory powers. And he also compared the projectiles taken from the body of the deceased to the ballistic signature of Mr. Silvera's firearm containing on the IBIS database, and he got a match. This led him now to do a physical examination of the ballistic material. So the expert contacted the Firearm Licensing Authority and requested the physical ballistic material belonging to Mr. Silvera's Glock pistol. The FLA provided the material to the Institute of Forensic Science and Legal Medicine. The expert did a comparison, and the spent casings in the FLA's possession that came from Mr. Silvera's firearm was compared against the projectiles, that is the bullets taken from the body of the deceased, and it was a match. He went further. He did a comparison as well between the spent casing, that is the ballistic material from the FLA, to the test fires that the ballistic expert, did of Mr. Silvera's firearm in January of 2024, and arrived at the same conclusion. That is, he saw level 1 matching and some amount of level 2 matching. The expert goes on to say, according to the Crown, having looked at the barrel of the firearm closely, he saw what in his opinion would have been the existence of corrosion or the existence of a corrosive material being introduced into the barrel of the firearm. But based on the extent of the level 2 matching of the characteristics, he was able to say that these projectiles came from this firearm. Now, additional narrative here. The Crown outlined that each time an individual renews his or her license for the firearm, the authority itself would take the firearm and inspect it for modifications or any signs of tampering. The narrative from the Crown is that on the 29th of September 2023, Mr. Silvera renewed his license and the firearm was inspected on that day. The information from the Firearm Licensing Authority is that no signs of tampering were observed during that inspection. And then, after the conclusion of the ballistic examination, no surprises here, Mr. Silvera was taken into custody. I think he was already in custody before, based upon the narrative, but anyway, he was now arrested and charged. The expert expressed the view that the corrosion could not have occurred naturally based on what he saw. In fact, he said that that type of corrosion would normally occur in firearms that are kept in water, or firearms that are buried in some areas as frequented by liquid or some other form of substance. He expressed a view that it could not have occurred between the 29th of September 2023, when the firearm was examined by the Firearm Licensing Authority, and January 2024, when he, the expert, did his examination. So he was then, that is Mr. Silvera, arrested, charged for the offenses of using a firearm to commit a felony and murder. And after that narrative was outlined, then the Crown indicated that they were minded to accept the plea. So that's part one of my remarks. So now, let us put things in perspective. The legislation that governs offenses of this nature is the Offenses Against the Person Act. At Section 6, it says, and I'm missing the first few letters here. So let's find one with all the information present. Section 6 says, where on a charge of murder there is evidence on which the jury can find that the person charged was provoked whether by things done or by things said or by both together, to lose his self-control, the question whether the provocation was enough to make a reasonable man do as he did shall be left to be determined by the jury. And in determining that question, the jury shall take into account everything done and said according to the effect which, in their opinion, it would have on a reasonable man. You have to forgive the gender of the language, but that was the language of the statute at the time. It applies to both men and women. So the point is that what Mr. Silvera outlined in his statement, had it gone to trial, would have to be put to the jury for them to consider whether he is not guilty of murder, but guilty of manslaughter. And let us not forget that in the context of a trial, the jury, in its wisdom, can acquit completely, because we seem to forget at times that juries don't have to accept any fact that is put to them. They are constantly reminded of this. So a jury, if they analyze evidence and they conclude that no offense was committed, then they are duty bound to return a verdict of not guilty, because at that point the only opinion that counts is theirs, not the judges, not counsel for the defense, not counsel for the prosecution. So, having regard to what is in the statement, though he was indicted for murder, the question of manslaughter would have to be left for the consideration of the jury, and they would have been told, among other things, that they cannot convict of murder unless they are sure that provocation or lack of intent or any other factor that will reduce it to manslaughter didn't arise on the case. So now, let us put this in perspective. So manslaughter is best understood if it is seen in the context of homicide, and homicide is a generic term, killing of one human being by another. And in our criminal justice system, homicides are classified as either murder or manslaughter. And I'm excluding, for the purposes of this, death caused by reckless or dangerous driving. So, murder occurs when a person of sound mind and discretion, by a voluntary and deliberate act, causes the death of another who is under the sovereign's peace, in circumstances where the person doing the act causing death had the intention to kill or cause really serious bodily harm, and while doing the act which causes death, there was no lawful justification, such as self-defense, or excuse, such as insanity, and so on. Now, manslaughter falls into two categories: voluntary and involuntary manslaughter. In voluntary manslaughter, all the ingredients of murder are present and would be murder but for the presence of a partial defense, such as provocation or diminished responsibility. It is voluntary manslaughter because the act which causes death was done deliberately, with the intention to kill, and would be murder had it not been for the presence of the partial defense. Involuntary manslaughter is so called because of the absence of an intent to kill or to cause really serious bodily harm. So into this category I find things such as unlawful and dangerous acts. You might push over someone or you punch someone in the face and they drop and hit the head and they die. Oftentimes in that context, the person doing the punching does not intend to kill or to cause any really serious injury, but it's an unlawful act. So that is the distinction really. And what is the significance of the distinction? It is now reflected in the approach to sentencing. So, manslaughter arising by provocation or by diminished responsibility, category into the category of voluntary manslaughter. Manslaughter arising from an unlawful and dangerous act or by gross negligence, involuntary manslaughter. In the case here, we are not dealing with involuntary manslaughter, but voluntary manslaughter. I make reference at this point to the social inquiry report, where the defendant was interviewed, and this is what he indicated to the probation officer. Said Mr. Jolyan Silvera was interviewed at the Kingston Central Police lockups. During the interview, he was respectful and cooperative. He stated that for several years prior to the incident, he and his late wife frequently argued, primarily over financial matters. He further disclosed that he was blamed for the death of their son, which further contributed to ongoing tension in the relationship. On the day of the incident, Mr. Silvera reported that an argument occurred between him and his wife. He explained that it was customary for him to leave and spend the night at his sister's residence following disputes. However, during this particular argument, his wife spat in his face and accused him of engaging in incestuous relationships with his older children and his sister. Mr. Silvera stated that during the confrontation, he reached a breaking point. He went to retrieve his licensed firearm to holster it, and as his wife approached him, the situation escalated further, and in the course of the struggle, he discharged the weapon 3 times, fatally wounding her. He admitted that he panicked immediately afterward and left the apartment. He emphasized that the incident was not premeditated, but rather the result of provocation in the heat of the moment. Mr. Silvera expressed deep remorse, stating that he is profoundly regretful that such a tragedy occurred. He acknowledged that there will be consequences to face, but he hopes that one day he will be able to meet his children again to seek their forgiveness. So, Mr. Silvera further explained that no professional intervention was ever sought during the course of their marriage, their marital difficulties. He described his late wife as someone who would escalate quickly during disagreements, going from 0 to 100 in no time. He stated that he often encouraged her to undergo an assessment to determine whether she might have been suffering from a mental health condition such as bipolar disorder. He added that matters worsened following the death of her mother, after which, quoting now, everything that could go wrong went wrong, unquote. And he noted that his wife did not cope well with her mother's passing. So, again, had the matter gone to trial and this information was presented as a part of this case, the question of provocation would have had to have been left for the consideration of the jury. Now, I'll go back to an earlier part of the prosecution narrative before, well, not so much the narrative, but remarks made by prosecuting counsel before getting into the details of the narrative for this specific night. The prosecution did indicate that there was information available to them from someone who had known Mrs. Silvera for a considerable period of time. And that person and Mrs. Silvera would have what she calls tracing, and by tracing, said she meant make up some noise. The prosecution also had information that Mr. and Mrs. Silvera would often have arguments, but they would call and make up later. And even in that context, the deceased would still push her point. She was very determined and excellent, according to this individual. Indicate that she was a loving mother to her children. And the prosecution also had information that Mrs. Silvera was very mouthy, and what was meant by that she was feisty and a strong-willed woman who was very smart. So that was information that the prosecution had in its possession, which they indicated to the court. And so that is part of the context now in which the plea for manslaughter to manslaughter was considered by the court. And certainly, in my view, what Mr. Silvera indicated as to how the argument developed is not inconsistent with what these other persons are saying. This is not a question of maligning the dead, but it is what it is. And the information is from persons who are, or some of, at least two of them are friends of the deceased woman and who knew her apparently quite well. So that is the additional information and context here. Now, I'm going further now into the sentencing process. This is now part 3. Sentencing is a complex process. It is a multi-layered and multi-factored process. There are factors relating to the offense itself which must be considered, and matters relating to the offender, and both interact, and that interaction assists in determining the appropriate sentence. It has also been said that sentencing courts must keep in mind what has been described as the 4 classical principles of sentencing: retribution, deterrence, prevention, rehabilitation. The authorities indicate that the court also needs to keep in mind the character and antecedents of the offender. So, in other words, even if you are dealing with similar offenses, the sentences may not end up to be the same mathematically, because there may be factors that are peculiar to one defendant that do not apply to another defendant, even in the same case if they are convicted for the same offense. The level of participation and culpability may very well vary. So it is not surprising then in some murder cases, several persons can be convicted, but one person may be an accessory before the fact, another may be the one who did the act that caused death, and so on. So you have the variations there. Now, for voluntary manslaughter, which is what we are dealing with here, it usually attracts a custodial sentence, and the custodial sentence frequently, not invariably, frequently is higher than the sentence for involuntary manslaughter, if for no other reason that voluntary manslaughter is closer to murder in the criminal calendar. So that is how the reasoning goes. Remember that voluntary manslaughter involves an intention to kill or cause serious bodily harm and would be murder but for the presence of the partial defense, as in this case of provocation. It is also a serious violation of the victim's right to life. And so, for those reasons, it attracts a custodial sentence. The Criminal Justice Reform Act tells us that the judge should proceed in a manner to consider whether a non-custodial sentence is appropriate, but the same act excludes firearm offenses, and even if that statute had not been in existence, the general approach of the courts has been to impose a custodial sentence in cases of voluntary manslaughter. So we are getting closer, not yet there, but we are getting closer. So we now come to how sentencing is actually done. So since 2017, we have had sentencing guidelines, and I emphasize guidelines. It's not a statute. It's a guide. What is the purpose of the guide? The purpose of the guide is to establish a consistent methodology to the question of sentencing. It is not designed to produce mathematical equality. So what it's designed to do? So when you come to look at aggravating factors, there is no such thing as this aggravating factor equals 2 years, this other aggravating factor equals 6 years, this other one equals 0, this one is 10, and the mitigating factor, if this is present, it comes down by 6 months, it comes down by 10 years, and so on and so forth. It is designed to guide the thought process of the sentencer, who should articulate how he or she went about the sentencing process. So in the event, well, firstly, the defendant would need to know why he got the sentence that he did. Let's start there. Persons who may be connected in this case to the deceased would need to know how did the judge get here, even if they disagree with the judge and they go outside muttering afterwards that this judge is a real fool. But they would still be clear as to the process, as to how the judge got there. And also, in the event of an appeal, the appellate court would have the advantage of seeing the thought processes of the judge to determine whether the methodology and the approach is in keeping with established principles. So we have the case of the Queen against Misha Clement. That has been the cornerstone of our sentencing practice. In that case, the late president of the point. So Trinidad was having the same issues that we were, some would say still are, having. And the Trinidad Court of Appeal looked at New Zealand and looked at other jurisdictions as well to deal with this question of a starting point. And after the examination was done, the Trinidad Court of Appeal decided that the starting point is defined in this way. That is the sentence considered appropriate for the particular offense of an adult offender after a contested trial. And that is the definition that I'll be using in this case to establish a starting point. Remember, it's just a start. The other thing is this, that this way of approaching sentencing, this new methodology, is different from what was called politely the synthesized approach or the instinctive approach to sentencing, where the judge just simply heard from counsel and then said, well, I think it is worth 15 years, and that was the end of that. Nobody knew what the considerations were. That is now considered to be inappropriate in modern sentencing practice. But one of the sticking points has been the starting point. How is it defined? How do you establish it? And so the Trinidad and Tobago has contributed, at least to my understanding, by saying it is the sentence considered appropriate for the particular offense, an adult offender, after a contested trial. So immediately, since it's a starting point, it is rare that it is going to remain there. The approach of the Court of Appeal of Trinidad and Tobago, similar but not identical to that of England and Wales, and also the Cayman Islands, where they seek to establish as well a starting point. And what I'm going to do is to indicate that using the Trinidadian definition of a starting point, going to indicate now what goes into the considerations to establish the starting point. And then here I'm going to be using the terminology from the Court of Appeal of the Cayman Islands, where they use the language of harm and culpability. What do they mean by harm? It refers to the result. What happened? How bad is the result? What actually happened? It asks as well what could have happened. And culpability looks at the blameworthiness of the offender. So it looks, was it deliberate? Was it spontaneous? Was it premeditated? Those are the things that go into establishing the starting point. Now there's something that is also a bit more controversial, and it has to do with how firearms are looked at. And here I must recognize the contribution of my judicial counsel, Mr. Blackwin, or Shane Blackwin, who has been very helpful in doing the research in this matter. And in looking at the cases here from our Court of Appeal, there don't seem to be very many cases that seem to treat with firearm homicides as a unique or separate and distinct class. Other jurisdictions have done so. So one says use of a firearm, they say you start high. Why? Because it results in a death. And then now, so that's on the quote-unquote objective side of it. And then on the subjective side now, you look at was it premeditated, was it spontaneous, and so on, to get a sense of where you should start. The other thing too is that the harm culpability approach refined in the Cayman Islands establishes categories. So within, for example, the offense of murder, you might have 3 or 4 categories, and each category has its own band. So for the offense of murder, you may find 4 bands. Band 1, this is the range of sentencing. Band 2, this is the range of sentencing. Band 3, this is the range of sentencing. They have also done the same for manslaughter, and they have broken it down now into manslaughter by provocation, manslaughter by diminished responsibility, manslaughter arising from an unlawful and dangerous act. And within each of those categories, you have bands within them. So again, it's not a one-size-fits-all, because the idea is, while you recognize the seriousness of the offense, you also have to take into account the offender before the court to arrive at what is considered to be the appropriate sentence. So that is the approach that I'll be taking. And then when the starting point is established, then you look more closely at the aggravating, mitigating factors in this particular case, then the next stage is to take account of things such as guilty pleas, previous behavior, good character, all of those things, and then you arrive at a final figure. So that's really the methodology. So from the research done, in Trinidad, as here, the maximum penalty for manslaughter is life imprisonment. One of the principles of sentencing is that maximum penalties are reserved for the worst of the worst, however defined. Some person may be wondering, well, how do you ever get there? Well, it's on a case-by-case basis. Some people are annoyed with that definition or approach, but there it is. So it is reserved for the worst of the worst. And the Court of Appeal of Trinidad and Tobago reminded us that even if the judge thinks that the penalties are low, the judge can't take it upon himself to say, well, in light of these low penalties, I am going to use the maximum as a starting point, because that is not the way it is to be done. So it is going to be very, very rare that the starting point is the maximum penalty in a manslaughter case. Notwithstanding that, the Court of Appeal in Trinidad and Tobago, they seem to operate in the range of 15 to 25 years for serious manslaughter. With regard to firearms, they give that special emphasis because in their view, firearms are inherently lethal and create significant risk to the public. And accordingly, offenses involving firearms in the Republic of Trinidad and Tobago are routinely placed towards the upper end of the manslaughter spectrum. And one case, Puran and the state, the court went as far as saying that where a firearm is deliberately discharged, substantial custodial sentences are justified, notwithstanding the presence of mitigating factors such as provocation or good character. In the Bahamas, that Court of Appeal there, they have identified a range of 18 to 35 years for serious cases of manslaughter. And they are of the view that manslaughter cases involving the use of a firearm should be to the upper end of the manslaughter spectrum. So too in Belize and also the Eastern Caribbean Supreme Court. So the sentencing methodology is not identical across those jurisdictions, but what seems to unite them is that firearm offenses are treated seriously and it elevates the starting point. Now, so I'm saying all of this to say that I'm not of the view that we're in Jamaica where we say that the range is from 3 to 15 is applicable here, since we did not and have not yet treated with firearm offenses in the way that other jurisdictions have. So, since we are dealing with voluntary manslaughter, it is the case that then it's a voluntary and deliberate act. And Mr. Silvera is not claiming that the gun went off. He's acknowledging that he shot her, but he's saying there was a presence of provocative words and actions. I also take account of the fact that certainly okay. We're going to pause a moment here, and I'm going to say this, so listen carefully now. No one is to have a cell phone or electronic device in their hands other than myself and counsel involved in the case, and the journalists. No picture taking is to be done. So if you don't have it in your hands, the temptation is reduced considerably. Or better yet, switch them off. So no picture taking. Okay? Yes. So, as I was saying, that our approach, as in Jamaica, has not yet gotten to the point of Aguilera, what they've done in the Cayman Islands and so on. But nonetheless, let us make a start. This case is also taking place in a particular context. What is the context? That Parliament has indicated through the Firearms Prohibition, Restriction and Regulation Act that the use of firearms to commit crime, whether licensed or unlicensed, is a very serious matter, and they repealed the old legislation and gave enhanced penalties. Now, we have a range, as I said, from 3 to 15. So it would be quite a remarkable thing to me if persons who commit non-fatal offenses with a firearm could end up with a higher sentence than a person who has committed a fatal offense with a firearm. So something just seems wrong about that. And so it is my view that in the present climate, reflected by legislative changes in other areas, homicide with a firearm could not be within the 3 to 15 range. It has to be higher than that. The other incongruity it would appear to me is this. The offense in count 1 charges the offense of using a firearm to commit a felony. Now, murder and manslaughter are not the only felonies that exist. Robberies are felonies. So again, you'd have the incongruous situation where a man who commits a firearm offense, in this case robbery, he may end up a longer time in prison because of the mandatory minimum, a longer time in prison than a person who has taken a life. So, that being the case, and having regard to what has been happening in other jurisdictions, how they've approached it, when you look at the harm, a death. A violation of the person's right to life. Regardless of how provocative they may have been, the fact is they have the right to life. And even persons on death row have the right to life. That is why the sentence is pronounced as to suffer death in the manner prescribed by law. So you can't have somebody running off the street and going on to death row and say, well, look here, man. Since you have been sentenced to death already, I'm going to save the hangman some trouble, and I'm going to kill you myself. So that wouldn't be death in the manner prescribed by law. So it was a deliberate killing, because that's what voluntary manslaughter is. And so in my view, a starting point should really be, in this case, about 25 years. So that is where I anchor the starting point. That is in respect of count 2. The harm was significant, and the culpability, in this case, the offender, is the principal in the first degree. It was his act that caused the death, and it was a deliberate and voluntary act. And that is also in the context of the movement to raise the levels of sentencing applicable to murder. So in my view, there should be a clear distinction between manslaughter and murder and wounding with intent. Yes, a very serious wounding with intent will maybe overlap with lower culpability manslaughter. A manslaughter sentence at the higher end may overlap a little bit with the lower end for murder, but nonetheless, the distinction between the offenses should be maintained, and offenses that involve a homicide should always be regarded as a class apart from any other sentence, if for no other reason that the victim's, the deceased's right to life has been violated in a fundamental way, and it is an irreversible state of affairs. Then now, having established this anchor point, the starting point that reflects the gravity of the offense itself, reflecting its seriousness, the degree of harm, the level of culpability of the offender, then we go on to the next stage now of whether there should be upward or downward adjustment. And just to make the point that when you're dealing with upward adjustment as a result of aggravating factors, downward adjustment, mitigating factors. Now, it doesn't mean that in every case there's going to be an aggravating factor or mitigating. So the judge is not to manufacture aggravating and mitigating factors. If none exist outside the commission of the offense, then that is it. So the judge can't go squeezing and torturing the evidence to find an aggravating or mitigating factor. Now, in this case, we have had submissions from counsel on both sides, and I thank them for their assistance. I mean, I really thank them, not saying it because there's something to be said. So, I've also had the character witnesses as well, coming in from the defense. The Crown is emphasizing these factors that it says are aggravating factors. That is, Mr. Silvera would have known what happened. The Crown is also suggesting that Mr. Silvera has been before the court since 2024, early 2024, January 2024. So what he's saying is not really anything new, because he would have known about the argument in the bedroom. He would have known that he was the one who actually shot her. He would have known that she was either dead or dying when he left, and there is no evidence that he sought any assistance from anyone. You know, there's an accident at my home, please come. It was the discovery of the body by the children and the call based upon the narrative that brought him back to the house. So the Crown's position seems to be that he should not receive any discount because of the guilty plea, or very little because of the timing. And then, so we'll see what we make of that at the appropriate time. But that's the argument as I understand it. There's also a statute that regulates or has some assistance, provides some assistance here. This is the Criminal Justice Administration Amendment Act of 2015, and Part 1A speaks of reduction of sentence on guilty pleas, and in particular, it speaks to first relevant date, which means the first date at which a defendant who is represented by an attorney at law or who elects not to be represented by an attorney at law is brought before the court after the judge or magistrate, and this is the critical part now, is satisfied that the prosecution has made adequate, not complete, adequate disclosure to the defendant of the case against him in respect of the charge for which he is before the court. So the whole idea there of the legislation is that it is not the first day that you appear before the court, but what information did you have from the prosecution that would enable you to make an informed decision. And so the prosecution's argument is that disclosure was made in early January. Post-mortem examination was served as well. So they are saying, separate and apart from what he knew, he also had information that outlined that it was his firearm that caused death of this person. And so the prosecution is suggesting then that the delay in entering a plea was, my words now, not theirs, playing the odds. Let us go along, see what happens, and then I will make a decision. So the prosecution is suggesting that this was a tactical move on the part of the defendant. And so the prosecution is suggesting then that this guilty plea, helpful as it is, should not, Mr. Silvera should not benefit from the generosity of the statute to the fullest extent. Well, we'll see what to make of that at the appropriate time, but the cases do indicate that a guilty plea is of value. What is the value? One, it minimizes, well, it removes the trauma of witnesses having to testify. It frees up resources so that it can be dedicated to other cases, and the person has accepted responsibility. So if for no other reason, then it should be recognized as a mitigating factor. So we have to weigh all of that. So in my view, in looking at this matter, what are the aggravating features? This is a killing in the context of a domestic setting. Mrs. Silvera was in her house. It is a place that she was entitled to feel that she could be safe, or at least not shot and killed. And the children have been deprived of a mother. So those are aggravating features. Another, to me, aggravating feature, because the narrative of the Crown didn't indicate whether death was instantaneous or she was a lie for some time. It wasn't clear on the narrative. But it means that if she didn't die immediately, then she would have been left there to succumb to her injuries. If she died immediately, based upon the narrative, these two youngsters, very young gentlemen, would have, as children normally do, you get up and you go into your parents' room. That's what children normally do, to stumble upon this there and leaving the children to make that discovery with no support. No, there's no evidence that any other adult was at the property. And so they did what children do, you call the other parent. And then, when he came, pretending that he was just as surprised as anyone else about the death of Mrs. Silvera. All of these, to me, are aggravating circumstances. In addition to that, let me get back to the narrative here outlined by the Crown in respect of the ballistic evidence. Because it was the ballistic evidence that anchored Mr. Silvera to the crime. There is no report that the firearm was missing. No report that it was mislaid. No report that it was stolen. And his initial response to the police granted, I will accept that the police officer had a responsibility. You can't be there being taken in by all of this. You go and you see a body. As a police officer, you're not a pathologist, but at the very least, you should be saying, don't touch the body. Call the crime scene persons. Let us see what happened here. So I wouldn't expect the police officer to be going over there pretending as if he's a forensic pathologist. But the police officer, being, I suppose, misguided sympathy here, was being taken in by the act of Mr. Silvera, to the extent that the police officer now, rather than doing his duty, he is now treating this as if it's just an unexpected death that may have been by a heart attack or some such thing. And during that, Mr. Silvera would have known that he was the person who was responsible for her death. The post-mortem says she got 3 gunshot injuries. And he was even telling the police officer that as far as he knew, she had no known medical condition that would cause her to be in the state that she was found, which is all the more reason why the police officer should have been far more alert than he was. And I had conduct of the matter when it first came for trial in February. And I will never say that a defendant cannot exercise his right to have the prosecution case tested. I have no difficulty with that. I have no difficulty with seeking your own forensic services. I have no difficulty with that either. But the fact of the matter is that when the matter came up, the defendant wanted his own forensic person, and that's fine. But it's in a context where you knew what happened. You knew. And when the forensic legal professional privilege, I won't get into that, but the fact of the matter is that it seems to me that the effort here was directed to see if there was some room to maneuver regarding the ballistic evidence, because that was the anchor of the prosecution case. And then, after you had that opportunity, then the guilty plea came. So in other words, from December 2023, right up to February 2026, it was a state of denial, non-acceptance of responsibility. So that is going to inform how I view the plea of guilty. Context matters. So yes, you have accepted responsibility, but it seems to me that the acceptance came because of the quality of the work done by the Jamaican ballistic experts. And what is the expert saying? The expert is saying two things. One level of marking, you get the firearm category. Two, next level of marking, I keep using the word marking, matching, you get the specific firearm. And he's suggesting that what he saw in the barrel was not the result of the natural processes of corrosion and so on, but a deliberate effort. And he's also suggesting that the impact would be that bullets fired after the interference may be different in its markings and so on to facilitate identification, different from markings before the gun was fired. In other words, we can't be sure. So that's how I come to it. And September 29, 2023 is a significant date. It shows the value of proper processes. The value of proper processes is that the FLA did what it was supposed to do. You come to renew the license, give me your gun, let me look at it. Do I see any signs of tampering, corrosion, anything altering? Because one part of their responsibility is to keep signatures of all firearms of private citizens so that the very thing that has happened here, the police investigation can proceed and you identify the firearm. But the problem was, and here's the problem. The problem was the pathologist. She was the fly in the ointment because when the body was removed, death from some cause other than violence, and it was the pathologist came along and said, what? No. We're going to deal with this differently now. It was her alertness. And based upon all the evidence, but for her alertness and professionalism, we wouldn't be here now. So that is part of the context for me. So those are the aggravating factors. Why are those latter things aggravating to me? Because it suggested an effort now to disguise, to cover up, to escape. And the science put naught to that. And when you had your opportunity to have your expert examine, no wriggle room. The expert, the Jamaican expert, couldn't be discredited. So we are here. Now, on the positive side now, the mitigating factors, which must be taken into account. No previous conviction, clearly. Person of good characters, King's Counsel said, you were an elected representative. Some persons may believe that that is not necessarily a mark of distinction, but nonetheless, the electors of St. Mary found that you are a worthy person to represent, and that must be taken into account. There's no doubt about that. The evidence of your character witnesses, because as I've always said, if you have lived hitherto a previously good life, and when you get into difficulty, your good character cannot assist you, then what is the point? So yes, it has to be taken into account. The impact on the children, that is to say, the surviving parent will be away from the children for some time. That's a mitigating factor. The social inquiry report speaks positively about your work, your contribution, the relationship with your children, and by all accounts, you're an effective father. And by effective, I don't mean just like functioning like an ATM now, but presence, active involvement, all of those have to be taken into account. The victim impact statements, counsel made reference to them, I looked at them. The jurisprudence suggests that they are not to be used as an aggravating factor, but to be taken into account in determining the initial categorization of the offense, but it is not going to, it's not supposed to have a decisive or impact to say the sentence goes up by a significant number of years, but it is factored into the process because there's always going to be a negative impact on those who are left behind. And it is not to be used to determine the level of sentencing ultimately. So it's taken into account. And as I said, and this is the difficulty in sentencing, there's no science that says aggravating factors mean you go up by 6 years, 7 years, or this particular factor is tied to a particular mathematical relationship. There's nothing like that. But nonetheless, it's a principle that we have to apply. And in my view, since I said the anchor point was 25 years, when you take into account the uplift as a result of the aggravating factors, I would say overall it goes up by roughly 6 years. The mitigating factors, it will come down by say, that will make it what, 31? From 25, the mitigating factors, you come down by say 4 years, that would leave it at 27. Now, having done that, we go to the statute now, where you look at things like the guilty plea. I note the words of the prosecution, and I am not seeking to undermine the defendant's right to have counsel. And of course, clients are like patients of doctors, they can give the advice, but they may or may not follow it. And so counsel has to work with the client that he has. I am not saying anything one way or the other, but it's just the nature of the job. A lawyer can only advise, but the clients have to decide. And sometimes it takes a bit longer for some persons to get to that point than others. And counsel may very well point out all the rational arguments as to why they should do things at a particular time, but some clients just don't act in the way that they ought to. There's nothing the lawyer can do about that, but you still have to work with the material that you have. So counsel referred to the Criminal Justice Administration Act of 2015, where it says, pursuant to subsection 1, the court may reduce the sentence that it would otherwise have imposed on the defendant in the following manner, where the defendant indicates to the court on the first relevant day that he wishes to plead guilty to the offense, the sentence may be reduced by up to 50%. Well, I don't think we're at the first relevant date. Let's go to paragraph B, where the defendant indicates to the court after the first relevant date, but before the trial commences, that he wishes to plead guilty, the sentence may be reduced by up to 35%. I think could say that he fits in there somewhere, where the defendant pleads guilty to the offense after the commencement of the trial, clearly not there. So where we are is paragraph B, after the first relevant date and before the trial commences. It says may be reduced by up to 35%. Now, what this provision is designed to do is to incentivize guilty pleas. But I suspect, and this is something now for law reform and the legislation, when you have the pairing of the offenses here of manslaughter, which the judge has more discretion there, with using a firearm, which is a mandatory minimum, then you wonder how does a defendant get the benefit of this? It's because if you plead guilty at the earth date, it's a minimum of 20 years, and if you plead 12 months later, it's still a minimum of 20 years. So that has to be taken into account as well, because there's really no benefit, really, for entering an early plea where you have a mandatory minimum of 20 years. So maybe the legislation should say something like, if he indicates on the first relevant date that he wishes to plead guilty, then notwithstanding the existence of a mandatory minimum, then the court can go below the minimum, because what you want to do is to incentivize persons to enter pleas rather than make it virtually pointless to enter a plea, since you're going to end up at more or less the same place, whether you go through a trial or you enter a plea. So I can understand those considerations. But nonetheless, he entered a plea, and it is of value. And I've indicated what that value is. So that should result in a further reduction. I don't think it's going to be as high as 35%, because of the context in which the guilty plea occurred, but nonetheless, it is a value. So, and in this particular case, had it gone to trial, quite likely the crowd would have had to call the children to give the evidence, and so that spared them the difficulty there, which is something that inures to his benefit. So, again, there is no precise mathematics here, but in the context of this case, I think that is worth a further reduction of 4 years. That takes us down to 23. Not going to get into the percentage, but certainly not 35%. So that takes us now down to 23. This is in respect of count 2. Other factor is a question of remorse. It's one of those intangibles where is the guilty plea a reflection of remorse, or is it a tactical consideration? Well, I have indicated my position on that, and it seems to have been a tactical consideration rather than remorse. Though I acknowledge that he said in the social inquiry report that he's remorseful and all of those things. But having regard to the broader context, I think it was more strategic than remorse. But nonetheless, it's a guilty plea. Nonetheless, he has been in custody for 2 years plus, so that's 2 years from 23. And 16 days? Yes. Okay, let's call it 20, is what, 25, 26 months? 26, let's call it 26 months, 2 years down from 23, that makes it what, 21, and then you take out the 2 months, so that's 20 and 10 months. And I'm just checking to see if there's anything else that I need to bear in mind in terms of mitigating factors and their impact. And that seems to be it. I think that is it. Right. So, in terms of count 2, we are at 20 years, 10 months, and that's the time for count 2. In respect of count 1, well, I'm just a trial judge. I am not at liberty to ignore the words of the parliamentarians, and they have indicated that there is a minimum and a maximum, and they have indicated that the minimum is 20 years, maximum is 25. So again, a guilty plea is of inherent value, whether it shows remorse or not. At least that's my view. And so I can't go below what Parliament has said. I know Mr. Champagne has referred me to the decision from the Privy Council, but they are the Privy Council. So I think that it would be improper of me to do that, not because counsel is inherently wrong, but I think it is something that deserves full argument, that all the circumstances surrounding the legislation and so on, and all the relevant case law has been examined. It's very difficult to do that in the context of sentencing, and unless it's a clear authority from our Court of Appeal or the Privy Council to that effect. So in respect of count 1, sir, sentence is 20 years at a minimum. So the other principle of sentencing is that sentences arising out of offenses arising out of the same factual circumstances are to run concurrently unless there is some good reason not to do so. There is no good reason not to do so in this case. So both offenses, sentences on both offenses, count 1 and count 2, are to run concurrently. So it's 20 years on count 1, 20 years, 10 months on count 2. And so we are now happily at the end of this process. So let me again thank counsel for the Crown and counsel for the defense for the work that they have done, and again to recognize the significant work done by my judicial counsel, who at times I gave him things to do at very short notice. I know that he was up late at night doing the research, so I thank him again. So he has enabled me to be here this morning to do this. And Just again, a gentle reminder to the media, please do your reports in a manner that the persons, witnesses, or otherwise can be identified. Okay? So, that's it then. So, let's adjourn.
Stand, please.
Yes? Should be stated. Oh. Okay, let's all sit, have a seat. Yes.
In relation, my lord, to section
101 of the new act.
Indeed, so, my lord.
Yes.
Subsection 8, my lord.
101.
And paragraph B, my lord.
101 section
8, my lord. Paragraph
Thank you.
Okay. Okay. So I'm being reminded here that section 101 of the Firearms Prohibition, Restriction and Regulation Act says, among other things, 101 subsection 8 says, unless otherwise specifically provided in this act, the penalty provided for an offense against this act is life imprisonment. Notwithstanding anything in the act, the court shall specify a term of not less than 15 years that the offender shall serve before being eligible for parole. Well, that doesn't apply since the sentence for 14(2) is not life. And it says the alternative now is where there's a prescribed minimum. Notwithstanding anything in the Parole Act, the court shall specify a term of not less than 10 years that the offender shall serve before being eligible for parole. So I need to specify a term. Oh, well, okay. So anything on this, you have to give counsel a chance to be heard here, though.
Well, my lord, given the context in which, in terms of the plea, I would invite the court to invoke the minimum. My lord.
Very well. Subsection 2 of the legislation prescribes a minimum period of 20 years, and Section 101, subsection 8 indicates that, notwithstanding the Parole Act, the court shall specify a term of not less than 10 years that the offender shall serve before becoming eligible for parole. Now, well, clearly, I think in principle, the minimum, well, it sets a floor that you can't go below 10 years. So it now means that you have to go somewhere between 10 and the 20 years. The further context is this. The purpose of parole is to encourage good behavior. That's really it. So persons who behave well and are an asset and a credit to the institution while they are there should be able to use that as a basis for earlier release than if they were recalcitrants there. So it is really an incentive for the rehabilitation process. Now, it seems to me in principle, the difference between the stated sentence and the parole eligibility period should be sufficiently wide to incentivize good behavior, because if I were to say 17 years, then I mean, really, what's the point? So I think that having regard to the fact that this felony resulted in a death, it should be higher than the 10 years, because offenses other than death are at 10 years. So I don't think both of them in principle should be the same. But the question is how far up? So again, no science here. So it must be sufficiently wide to be meaningful. And so that is what I'm going to do, and suggest that the minimum period before becoming eligible for parole in respect of count 1 should be 13 years.
I didn't hear, Lordship.
13.
13, thank you.
13, 1, 3. Yes. So, I think I've covered everything now, I hope. Yes. Thank you all very much. Let's say the adjournment, please.
Stand, please. This honorable court now stands adjourned. God save the king.
For joining us for the live stream in the matter of the king against Jolyan Silvera. We encourage you to follow us on our social media.
Welcome back to Silvera learns his sentence. Well, no, Silvera has been sentenced 20 years and 10 months on count 1 in this matter and 20 years on count 2. Let me just double check that for you, and just to remind our viewers that Mr. Silvera was charged for committing an offense with a firearm and also manslaughter. Well, he pleaded guilty to those. So count 1, 20 years, count 2, 20 years and 10 months, both sentences to run concurrently. And as you just heard, if you were watching, he will be eligible for parole after 13 years. Alexander Shaw now returns with us here on CVM TV, Attorney at Law Alexander Shaw, and momentarily we will be joined as well by attorneys Leonard Green and Bert Samuels, just to get some quick reactions before we go. And as you can see on your screen just now, our graphic going up, 20 years and 10 months for Jolyan Silvera. What's the significance of this, you think, given all the discussion that we had leading up? You were closer to, it was closer more to what you were saying than to what Bert Samuels had predicted, Mr. Shaw.
And the reason for that is we're talking about the Chief Justice here, and albeit I think he said it, he has to abide by the law, and he can't operate outside of that. And even though he's only guided by the sentencing guidelines, he can't go too far, because we're still talking about a manslaughter offense here. So I never expected him to go beyond the 25 years.
Yeah. What did you make of his reasoning? He spoke, for example, about what he called the tactical acceptance of responsibility, the tactical timing of him saying it's manslaughter versus the chances he had before when he could do it, and in how he viewed the timing of all of that. What did you make of his whole reasoning? It was, I thought it was so easy a 7-year-old could follow.
Well, listen, quite frankly, it was a masterclass, a very surgical operation, and any non-legal mind or jurist here would be very impressed with how he actually laid out things, the way in which he delivered. His presentation was, impeccable, I must say. But the truth is, I think he did Jamaica justice in how he handled this matter, because it was a very difficult and complex exercise, and we saw where he carefully, tried to balance the scales of justice. He looked at the aggravating factors and he looked at the mitigating factors. He took into consideration even the victim impact statements. So everything formed part of his judgment, and ultimately inured to whether the benefit of the accused and even the victims who have to deal with this going forward.
Yeah, the 13 years parole eligibility now, so quite literally in another 13 years from now, Mr. Silvera could be walking a free man. Persons will be saying, boy, somebody guilty of just having an illegal possession of firearm maybe get a mandatory minimum, has to serve a mandatory minimum of 15 years. He's now eligible for parole after 13 years. He could walk free. Well, foreseeably, we're in 2026, 2036, 2039, basically.
Well, what I can say is that eligibility doesn't automatically mean that he will qualify for it, right? And even though there has been a consistent theme in sentencing, though, in that all his witnesses have said that he's actually a person of good character and so forth. So that may help him in the future. But even though he may become eligible at some point, it doesn't mean that he will actually walk out at 13 years, because I would want to, that is a question really for the parole board when they come to assess whether or not he should be out in 13 years. But I can understand why the average man would be frustrated with that. And given how Parliament has gone very far to even set mandatory minimums, but when we are treating with these matters, I think, you know, everything has to be looked at on a whole, as opposed to, okay, a singular offense of say, using a gun to commit a felony, mandatory minimum 20 years. But then you have to bear in mind even that very section about parole, because, you know, you may very well undermine what you're trying to do. And
do we not run the risk in this instance? Because I'm now here, if he used a firearm to commit an offense, the law says it should be a mandatory minimum of 20 years. But
years.
now I'm hearing 13 years for if he behaves well in Parliament, and based on his antecedent, based on the reports coming in about him, you know, he may very well get 7 years off that. That to many people, to the average person looking at it, as a boy, a joke thing that you kill a wife and you can come out in 13 years, it's going to behave good.
And that is really something for the lawmakers to consider. In that, in strengthening legislations, in increasing penalties, it can't be done in a vacuum. You really have to take into consideration all the relevant laws that will apply, because you realize that it was actually in the very, almost to the end, that that was raised, because, you know, the judge was focused really on the substantive sections of the legislation. So I expect that there will be some uproar, but what I can say at this point is that it doesn't necessarily mean he'll be out in 13 years. That's perhaps the only comforting thing I can say.
Yeah, I'm seeing a lot of people reacting here on CVM's live, and we are streaming live as well for our viewers. We are on YouTube and also cvmtv.com, and of course, please follow our social media pages. Our page on YouTube is CVM TV News, and we are seeing some of the reaction shares. Many people saying that if he ended up with the minimum, one comment, this is coming from Birdie Max, saying if he ended up with the minimum 20 years coming down from 31, it means that he got all the deductions of mitigating circumstances and no additions of the aggravating circumstances. Do you agree with that?
Well, the case can very well be made that maybe more mitigating factors were taken into account than aggravating factors. But what I must say, though, is that this is a very unusual case, because what
unusual
we expect,
in what sense?
In the sense that for manslaughter, you don't really see people getting sentenced in the 20s. It's usually in the teens, right? So the average lawyer perhaps was expecting at the maximum 18 years. The presence of the firearm, which is what the judge emphasized, is what took it way beyond the 25 mark, because he started very high. 25 years as a starting point is very high. In fact, I must say the sentencing guideline, the guidelines as they are now, stipulate a starting point of 7 years. He did not follow that. He used, I think, the case of Aguilera, that Trinidadian case, to say that, listen, this is a very unusual case, and let us take into consideration the amendments to the Firearms Act to now include a mandatory minimum of 20 years for offenses committed with a firearm. And so it was a very complex and difficult exercise.
Yeah, we are upon our first break here. We are just getting some quick reactions to the sentencing of a former member of Parliament, Jolyan Silvera. In case you're just joining us and in case you have not seen it or made aware just yet, Jolyan Silvera was sentenced to 20 years and 10 months on count for the killing of his wife. On count 1 it was 20 years, and on count 2 it's 20 years and 10 months, and both sentences are to run concurrently. He is eligible for parole after 13 years. Stay with us, we'll get some more reactions when we come back, and by then we will be joined by attorneys at law Leonard Green and Bert Samuel. Stay with us, we'll be right back.
The morning. Elegance isn't just seen, it's sensed. Set on Jamaica's north coast, the Montego Bay Convention Center rises with intention. A space designed to inspire, connect, and lead. Polished, purpose-built, poised for what's next. Step into a venue where scale meets serenity, where openness isn't just a design, it's a philosophy. This is more than a venue. This is where vision checks in.
In need of a loan? AIM Financial is the place to go. We have loans from $20,000 to $3.3 million. Get a loan to pay school or college tuition, medical expenses, bills, fix up your house, buy furniture and appliances, repair or buy a car. And when you're done, take a vacation loan. AIM has a loan for any purpose. Call AIM today. You won't find a better deal elsewhere. Guaranteed.
Every dream conquered is another dream game. I land and I fly again like a jet plane. Headed straight in your direction, 'cause I'm wiser, one step closer. I'm winning 'cause I work so hard. And the music keeps on playing, and the people them I say we are my show tonight. Keep on believing in the power of the feeling. Whatever you want, take a chance. Song in your heart, step in your dance. You got a spark, don't fit it down, shine your lights on.
Let's delve deep into the issues. We'll take you beneath the surface.
Greetings and salutations. My name is Orvin Higgins, and it's another edition of Fan Central.
Talking to the people at the heart of the top sporting stories. Hear from your favorite sportsmen and women and the administrators who work tirelessly to make it all happen. It's live sports talk.
I've written an entire article.
Yeah. Looking at all the major issues every Tuesday at 9 p.m. It's Fan Central.
If you're a woman in business, it's time to go bigger.
Your ambition is calling, and Horizon for Women in Business is answering.
Horizon, a new loan product from Access Financial Services designed for women entrepreneurs to unlock the capital you need to grow and take your business beyond limits. With quick approval, flexible repayment, and low interest rates, your success is on the horizon.
Call us now. The funds are waiting.
Your success is on the horizon.
Hey, what up, one?
Hi, I am Candy Pang.
What a guan? What a guan?
That a guan, pa.
What a guan? What a guan?
What a guan! Mondays, Wednesdays, and Fridays at 8 a.m., 1:30 p.m., and 10 p.m. on CVM TV.
That's a guan, pa. What a guan?
Tune in to Lead Story. Weekdays at 6 p.m. Hosted by Jolyan.
Brought to you by Horizon, a new loan product from Access Financial Services.
Every dream conquered is another dream game. I land and I fly again.
Welcome back to CVM's special coverage of the sentencing of Jolyan Silvera. In case you're just joining us, the former Member of Parliament has been sentenced to 20 years and 10 months in prison. He is eligible for parole after 13 years.